760 and thousands of cases, my lord.
Thank
That
you.
is congratulations.
All because of you.
No, no, my lord.
Thank you very much. Let us do together
All of you, my
some
lord.
more work.
Will
Some
not
more.
ask for your thought.
Thank you.
We should expect from the Supreme Court, your lordship should be elevated to the Supreme Court and we should
In any
get
case, I'll go there only, but in what capacity, I don't know. Thank you. Thank you. Yes.
Pardon the mic mention, my lord.
Yes.
In the POCSO Act, matter has already been compromised between the parties. And petitioners
What compromise? They have married or what?
married to marry, because before allegation also both were loved each other and they were agreed for
What is
marriage.
the age of the boy?
Now boy's age is 20 and girl age is more than 18.
I mean, pardon to mention, vigilance matter against the acquittal appeal.
Against the acquittal. What do you want?
For listing the matter, advocates were listed in the last week of.
You have already been acquitted. You want a conviction or what?
I want to finish the matter.
Oh, the state has filed it.
Yes.
Oh, wait, you are acquitted. Who is good?
No, but
I'm not going to interfere in
Madam,
acquittal.
service benefit has not yet been given
All
to the
right, you
party.
give it.
For this reason, old
Regulament, must be regulament.
Yes, GCRLA.
Ah.
Mr. Sangram Das is.
All right.
bail application
My lord, yes.
already serially crossed, my lord, but it has not
No,
been
no,
listed.
no. Serially will not cross. Don't worry.
3287.
You give it, serially will not cross. If everything will come in serially. Don't worry.
326.
And serially,
The
why
serially-
serially might have been crossed because you might have managed not to get the matter listed. And
No,
the
again,
file
what-
must be misplaced somewhere.
No,
That is another problem we are facing. Deliberately, few files are not traceable in the registry.
No, I'm giving.
And who is behind it, you know. You file it and keep it not listed, not allow the registry to list it for reasons you know that. And now you want that everything should be listed. All these things are happening, so serially it will come. Don't worry.
Pardon, my lord. Yesterday list was item 19 not listed today. Well, lordship said today list will come tomorrow, but mine case is not listed today. It is
3
twice.
PM.
times.
Today, 2 matters at 3 PM.
Oh, so today's board is very heavy, so that's the reason.
Milord, what-
Just see, check it out. Because
what my
what-
difficulty, Milord?
1 minute, 1 minute. You are trying to say that the leftover matter
No,
was
no,
supposed to be
it is one-
spill over to today. Your matter could not be listed. That's what you are saying. Just check it out. Huh?
The same is in my case, 98. As per the my mention, your lordship was pleased to direct to list it.
No, because there are few specially fixed matter at 3 o'clock, so therefore they thought there is no point listing it.
No matter, right? It may be listed because the date has been fixed to 10 for defense evidence. I am for the complainant opposite party. He is taking time since January 2024.
Just check it out.
98.
Pardon, my lord.
Lordship, my matter was also specifically fixed today at 3 PM. That Bangalore,
It was listed yesterday.
no, it is in weekly list 130. Sorry, the senior advocate has mentioned Tuesday that
It is
Bangalore.
must be there in the list, weekly list.
Now, you had been told to be specifically listed today.
It is there in the weekly list or not?
Yes, your lordship.
Then the moment I'll get free, I'll hear.
My lord,
Pardon, my lord. My
Ma-
lord, BLAPL 5729 of 2024, my lord. I have filed an IA for interim bail on the ground
Interim bail
of
on the what ground?
illness of his mother, my lord. Petitioner's mother, my lord.
See, if I found it is a frivolous, then I'll dismiss the main plea also.
Yes,
Main
my,
plea also.
my lord.
Give those applications are also getting listed serially. Just
my lord, some 3 items, 83, 86, 101, it may not reach by 3 PM. Apart from my difficulties, can it be, reply is to be filed in this, all those cases. I have given the list,
just note it down. 80.
83, 86, 101, 79 also. I have given them.
And somebody should remind me, that's all.
My lord,
You may go.
My lord.
Somebody should remind.
Pardon to mention, my lord. My lord, item number 50, today's list, my lord. That is the bail application number 3858 of
What do you
20.
want?
Petitioner has already faced the trial and been acquitted from the London trial.
52.
50, item number 50,
50.
50.
In fact,
Your Lordship, may be pardoned to make a mention. One cancellation of bail filed by the CBI, Your Lordship, it was directed to be listed on 25/8. However,
there is cancellation, no urgency. People are not getting bail, you are talking about cancellation.
Your Lordship, may I give the memo?
Give the memo, but there is no urgency.
Bill number 6092, I mentioned it yesterday, I'll withdraw my lords of 20.
Withdraw. Yes, it is listed.
No, let's know.
Withdrawal number not given, sir.
You give the memo.
I thought I'll give it in the court. Then 6092.
Yes.
Pardon me, lords. Item 12 minutes. 2 days list, my lord. I pray 2 weeks after. Because, my lords, the informant in the meantime, compromise matter, he has married, my lords, very recently. 2 weeks after.
I didn't to mention, my lord, item number 97. Kindly adjourn this matter on next 97.
Interim order is there.
My lord, item on
Interim order is there. Huh?
Yeah.
Press matter.
97.
Yes. All these matters will go to November end. Huh? Before that, don't ask. Yes. Because if you would not have asked for adjournment, some other matter could have been accommodated. Yes. No, yes.
Item 1.
Where is the accused? Where is the informant? Are they? Let them pass over. They are there. Yes.
Item 2.
Let them come with the HC. Yes.
May I please? This challenge the petitioner challenging the order of learned district judge under section 42384 506 34, my lord.
What do you want, madam? Yes.
Allegation of quashing of FIR.
FIR.
Yes, ma'am. Allegation that the marriage was fixed between the parties and at the time of marriage, one gold fingering of 50,000 rupees was given. And after that, the petitioner denied to marry her. Only allegation was that.
Denied to marry.
Yes, ma'am.
Okay,
In the last time, the state has taken time for the instruction regarding the.
But in fact, my lord, what happened, charge sheet has already submitted. There, my lord, filed the case for quashing of affair. Charge sheet filed under section 371, 417,
What is-
506, 376.
What is the allegation?
Allegation, my lord, this petitioner promised her to marry, my lord, and did not marry, my lord. For thereafter, my lord, taken her to Puri and committed sexual intercourse with her.
No, 376 is also.
Three converted charge sheet 376.
Right, at the time of filing.
Passing is not possible. Any other relief you want? Tell me. You are on bail?
Yes, ma'am.
You are on bail. Passing is not possible because
376.
charge sheet has been filed 370. If you settle the dispute, then no problem.
Then,
Petitioner is already married, ready to
Maybe,
marry.
but she should come and say that I don't want to prosecute. Then only it can be quashed. Otherwise, you can't.
Let them appear, my lord.
Why should I ask you? Have you implemented?
No, my lord.
You have not even implemented. You do one thing. You, since charge sheet has already been filed, you file a fresh petition impleading the informant. Then you come to me. Right? Then counsel for the Mr. In this petition, petitioner has challenged seeking quashing of FIR. FIR. Gram Ganjam.
Gram Ganjam.
Gram Ganjam.
Yes, sir.
Gram Ganjam PS case number 79 of 2023. Mr. Ragada, let counsel for the petitioner submits the state submits that in the meantime, charge sheet has already been filed.
submitted on 13/5/2023.
Filed on 13/5/23.
On offense under section 371, 414, 506.
For
417.
offense, for alleged offense, punishable under section
3761, subclause 1, 417, 506.
5. In view of the aforesaid development, the learned counsel for the petitioner seeks to withdraw this petition to file a fresh petition. Fresh petition with this liberty, the petition is disposed. Yes.
Oh, bless you.
Item 3.
Yes, sir.
For the petitioner, also, I pray that matter be taken up.
Taken up?
I pray for her. Also,
I-
can't see it, how many days they have taken because of the pendants of this application. My lord, no proceeding is.
No, where is there any interim?
No entry about that.
It has not been
This matter is pending for your lordship 143A. Notice has not got petitioner, my lord. And challenging that order for 1 year passed by. 1 year of already passed, no, it has not been admitted or no, interim order has.
No, he challenging what?
One interim compensation awarded under section 143A of NII. Against that order.
Since there is no stay, you can do it.
London court is not proceeding, this matter is pending for the.
I, Learned counsel for the petitioner seeks an adjournment in this matter. It is at the request, it is urgent to sunset. It's made clear that the pendency of this petition shall not be renewed to the benefit of the petitioner for seeking adjournment for the trial. Adjourn, no more. And you show it and let the
Yes,
thing
yes,
proceed.
that way.
It is negative stay.
Item 4.
4, my lords, may I please. Item 4, my lords. Here the offence alleged against me is under sections 420 as well as 13 of Prevention of Corruption Act, my lords.
Yes.
As this is a matter
Mr. Maharana.
arising out of vigilance. Yes,
Nay,
ma'am.
Mr. Maharana has some personal problem.
Court number 3.
Adjourn, huh? Mr. Maharana has some personal difficulty, so therefore he seeks an adjournment.
Item 5.
My lords, may I make one prayer if to your lordship's approval?
They give a date from them.
My lord, just, my lords, may kindly fix a date because this is,
Date will be fixed. In my court, have you seen without fixing a date?
I bow down.
It will be.
Item 4. Item 5.
Deeply obliged.
Item 5, my lord, the
If it's
discharge
your-
petition he has challenged.
Yes.
Item 5, my lord, he has filed the discharge petition. When the charge was framed, after 1 month, he has filed the discharge petition, and that he has challenged this. And it is of 2019 matters.
Right.
Can you see, my lord, that order?
Petitioner,
45?
you give me the dates, huh? Petitioner has assailed the order dated 3/10/2023, passed by the alleged CJ Jagat Singhpur in ER case number 7377 of 2011, whereby his application for discharge has been rejected. Learned counsel for the state submits that the discharge application was indeed filed by the petitioner after the charges had been framed on
7/3/23.
7/3/2023. Therefore, the trial court has rightly rejected the application seeking discharge.
My lord, that discharge petition was filed on 7/3/23. And the charge was framed on 7/2/22.
7/2/22,
my lord.
27/2/22.
7/2/22, 7/3/22.
Although, see, नहीं, कौन लिख ले, confuse करो, कौन लिख ले? Although the discharge application was filed by the petitioner on
7/3/22.
7/3/2022. However, the same was disposed of by the impugn order by that time on
7/2/22.
7/2/2022. The charges had already been framed, the none APS for the petitioner. On the last date of hearing, that is 8/8/2024, also non-appeared for the petitioner, and this court had adjourned the matter, granting an opportunity to the petitioner to cure the defects. It appears defects have been cured, but non-appears for the petitioner even today. Therefore, the petition is dismissed. Yes.
Item 6.
The third point decided by your lordship is whether at the instance of the informant, re-investigation could be made or not. I have filed a petition before the Law and Trial Court under section 173(8).
Being informant, you are the informant.
That was the rejected.
That was it.
All the governments are against me, but here the fact is a little bit different. When I was injured and went for the treatment, my lord.
Why didn't you get it routed through the PP? You should have asked PP, because 301 also says that CRPC 301 or 302, whatever. It says that it has to be through the PP only. You, at your instance, it can't be.
My lord, here, my lord, what happened? Charge sheet was submitted under section 3067. And he has, his prayer is that the investigation agency has not collected all the relevant documents. In the meantime, 4 witnesses were examined. He has not filed that application 173 application has not filed before the London Magistrate Cognizance Court, my lord. Third thing is, my lord, that document can be exhibited at the time of trial, my lord. So why it is the need and necessary that
Why are you agree with?
I approach the local police, the investigating agency. Thereafter, I approach the SP.
Whatever, maybe, but legally you are not permissible. Better you withdraw it.
They will permitted to approach the.
Right on. London Counsel for the petitioner seeks to withdraw the present petition to raise all his objections before the court below. With this liberty, the petition is disposed. Yes, yes.
Item 7.
on behalf of Ms. Ota, I pray that the matter be taken up some other date. Your lordship.
Adjourn or request.
Obviously.
Is there any entry order? No.
No.
Adjourn or request. No more. Yes.
Item 8.
My lord?
Yes, yes.
Yes, my lord, I am at VC Sambalpur.
Yes, yes.
This petition under section 482 CRPC has been filed for the quashing of FIR, my lord.
Yes.
The petitioner, there are 8 number of petitioners. In this case, my lord, one FIR has been instituted against all the petitioners along with some others. This
Why should
petitioner,
it be quashed?
my lord,
Why should it be quashed, you tell me?
there is no ingredients of 420 and 406.
Investigation is going
Absolutely.
on. Investigation is going on. How do you know ingredient will come or not?
Yes, my lord. The FIR, the contents of FIR does not require any
That is
single
the reason,
file on
sir, that is the reason there is a process of investigation. Maybe a false FIR, maybe whatever. Investigation is going on.
it is absolutely civil in nature, my lord. The facts of the case.
Yes, no, I have brought it. I have brought the charge sheet, but it is 420, 406,
The
34 there.
petitioner has said, petitioner in this petition is seeking quashing of FIR being PS case number 140 of 2020 and allegedly registered against the petitioners under section 420/406 and 34 IPC. Investigation has already been meanwhile, investigation has already been completed. And charge sheet has already been filed?
Yes, lordship.
Charge sheet has been already been filed on
3324.
3321.
24.
3324. This therefore the petitioner seeks to withdraw this petition to avail the remedy under law.
My lord,
and
permitted.
the change in circumstances.
I
Charge sheet
have
has
put
been
it-
filed, you just see what are the allegations.
Yes, my lord. I have another PRO 411. All the petitioners are about 60 years or more than 60 years. Some are bedridden. So bail may kindly be granted, my lord.
Self-help group.
All are old women. All are old women.
I understand it, but in 482, how can I grant bail? Your bail applications are rejected.
No, my lord.
You have to
No,
approach
no.
the right court. If your bail applications are rejected, then I can think of doing something so that you will not be arrested. You have not approached the bail court at all.
On IA, I have filed the IA.
And these offences are minor offences, you will get the bail. What is the big deal about it? Approach. I give that liberty also.
Direction may kindly be given, my lord. All are old and sick. Some of them are dead, my lord.
Lordship, 41 is complied. He has able the 41, lordship.
See, 41 has already been complied. The police has given 41 notice. Why are you inviting problem for yourself? Are they arresting you?
Anticipating. Old women are all are
Why should you
illiterate.
file anticipatory 41? They have given charge sheet is filed. Someone will be issued, go and appear, you will be enlarged on bail. What is the big deal? I'll record that. At this stage, petitioner is insisting that the petitioners being the senior citizens shall be protected. The senior citizen and few of them being the ladies should be given protection from arrest. from arrest. The counsel for the state submits that 41A notice had been served on the petitioner during the investigation. In that view of the matter, I am not inclined to entertain the oral prayer made by the petitioner. Yes.
Item 9.
Nine. None appeared. Last time none appeared. What is this matter?
Compromise they have made, but that is affidavit they've given the compromise application, what? They have not come.
Let us pass it over because last time also none appeared.
Yes, sir.
Huh?
कितना item?
So last time we will pass over.
As well as.
Item 10.
In this application, my lord, the petitioner pays for quashing of criminal proceeding, my lord, on the ground of compromise, my lord. Matter has already been settled between the party, my lord.
What are the offences?
365, 506 by 34 5 piece.
Charge has been filed.
No, my lord.
I'm appearing for the informant. Matter has been amicably settled between the
What are the allegations? Yes, Mr. Raghunath.
Compromise yet touch.
Compromise, they have filed.
There is a writing for the compromise lordship on
They
dated.
are also present.
There are.
Yeah, in the instance of opposite party number 2. Opposite party number 2, na?
My lord.
Opposite party
Lucky
number 2,
they were
FIR
annexed
number
to-
so under section so.
Lucky annexed to lucky.
The allegation against the petitioner FIR is that para 2 of the petition. Investigation in the present case. At this stage, the parties have settled them. The petitioners, who are the petitioners? Are they present? Sunil Jana, Lilendra Jana, and Bibuda Datta, and Santilata Mishra. Okay. The petitioners and the opposite party number 2 are present in the court physically, being represented by their respective counsel and identified by them. They've also filed the self-attested copies of their Aadhaar card to establish their identity, which are taken on record. The parties, medical kidnap. I'll impose legal cost actually. The informant and the victim in the present case have separately filed affidavit dated 16/5/2024, which are taken on record. In the affidavit, both of them are stated that on the intervention of the village local gentry, they have settled their dispute. The informant and the victim had no grievance left against the petitioners, and they joined with the petitioner for quashing of the FIR, regarding to the fact that the petition, the parties have settled their dispute, and they filed the affidavit. They are present in the court, and in reiterating the said fact, I am inclined to allow the petition accordingly. FIR number so, and consequential proceeding arising therefrom after past, subject to the petitioners paying 1,000 each.
My lord.
Subject to the petitioners paying 1,000 each as a cost to the
High Court of
opposite party number 2.
Open number 2. High Court Bar Association Welfare Fund.
If she has
My lord.
suffered, she has suffered.
Yeah.
She has suffered. So you are interested to give bar also 1,000 to them and 1,000 to bar. Okay. 1,000 each to the opposite party number
2, my lord.
and 1,000 and 2,000 to the High Court Bar Association. 5,000. He is interested to pay 2,000 to the bar and 3,000 to the lady. आपको 3,000 टका से देबे बर्तमान 3,000 टका देबे क्योंकि आपण जीवा से खर्च होइतिबो सेति give it and file the report. Then only it will be uploaded. Otherwise this will remain like this.
No.
Yes.
Item 11.
On behalf of Mr. Tripathi Miller, can I permit to withdraw my lord?
Yes, withdraw. Permit. Yes.
Item 13.
Yes, 13.
I think kindly pass.
Possible.
Parties have come, but
Yes,
advocates
yes,
for
no problem. 12 o'clock you bring.
12
The
o'clock.
parties are there.
Public. Parties has
After,
come.
yes.
12 o'clock, my lord.
Yes.
14.
May I
14?
please, Lordship? Lordship, in the present case, the apparent challenges the order dated 23/7/2024, wherein he was convicted on.
2 years conviction.
Yes,
There is a bill.
Yes, Your Lordship. He is all along on bail.
Admitted, bail granted, realization of fine, state, call for NCR. Yes, next.
Obliged.
Item 15.
Yes, sir. Yes, sir. Tell me.
Offenses under section 120B,
120B.
409 of IPC, reduce section 456 of price sheets and money circulation scheme management.
Money circulation scheme.
Yes, ma'am.
Okay.
The charge sheet submitted on 8/2/2017, and I was in custody. I'm in custody since 31/1/2020, madam.
31/1,
2020.
2020.
2020.
Charge sheet.
Charge sheet submitted.
When?
Charge sheet submitted 8/2/2017, madam. 2017.
2017.
2017. Charge sheet submitted.
Yes.
Madam, in the present case, the main accused person has been convicted as he was pleaded guilty, and the London Trial Court has convicted for a period of 5 years only, madam. Even if 409 is there, and I am in custody for more than 4.5 years, madam. And
Yes,
in the
who is
meantime,
appearing?
in the meantime, I have approached before the London Trial Court under section 436A, my lord, and the London Trial Court rejected my bail application.
That's what I was wondering.
Yes, ma'am.
36A, 50% of the.
Yes, my lord. As
Full
there is,
sentence,
as
you are
there
in
is 409, the London Trial Court rejected. And in the rejection order, the London Trial Court categorically mentioned, till date, out of 203 charge sheet witnesses, only 8 witnesses have been examined, my lord. There is huge delay in trial, my lord. My lordship, kindly.
Yes, who is appearing?
For
Yes,
CBI?
Yes, Mr. Naik.
Yes, your lordships.
See, the principal accused has pleaded guilty, 5 years sentence. So he has already undergone more than 2 years.
No, your lordship, that is not the
So
case. I'll
one
explain.
minute.
He's not explaining, your lordships, that he was charge sheeted as an absconder. The charge sheet was filed in 2020, your lordships.
17.
Your lordships, let me argue, your lordships. Your lordships, I've given a chart in which your lordships from 2016, your lordships had that chart my junior has given.
Yes, sir.
From 26/10/2016.
You were an absconder.
Yeah, yes, my lord. I
But he's not-
admitted. Even if I was absconded, I was in
When
custody
did you
since
admit? He's
2020, my
admitting now,
lord.
your lordships. Just 1 minute. Lordships, 26/10/2016, your lordships. First notice was given to Ranvijay Singh Baghel at his residence at MP. The notice could not be served to him, your lordships. The postman returned. Then, your lordships, 8/2/2017, your lordships, he was charge sheeted as an absconder in the case.
How many witnesses are there? You tell me.
Lordships is your lordships is a proclaimed offender. 82 proceedings have been initiated against him.
I understand. I am asking for some other purpose. You please tell me how many witnesses are there?
Your lordships, witnesses.
108, you say?
203.
203 witnesses are there, according to him.
But apart from that, also, your lordships.
One minute.
Yes.
I am something
Yes.
else. And how many witnesses are examined?
8.
Eight witnesses
It
examined.
is mentioned in the rejection order, my lord.
So I will seek an report from the concerned court. Let me see what is the position. Let me
Yes.
check. Okay, right down. Then comes for the petitioner submits that in the present case, the principal accused has pleaded guilty, and he has been convicted and sentenced to undergo RI for
5 years.
5 years. The present petitioner is in custody since 13/1/2020. Therefore, he submits that he has already undergone more than the 50% of the sentence which has been awarded to the principal accused. So therefore, hence, he is entitled to the benefit of 446 capital A CRPC. He further submits that out of 203 witnesses, only 8 witnesses have been examined as yet. Mr. Naik, learned counsel for the petitioner, submits that although the charge sheet was filed way back in 8/2/2017, but the present petitioner was an absconder, and he was declared as a proclaim offender, and subsequently he was apprehended. So
And your
therefore,
lordships, and furthermore, further investigation is going on. Final charge sheet has not been filed.
yes, subsequently he was apprehended, so therefore he is not entitled to the concession of bail. Moreover, further investigation in the present case is still on. Regarding head to the aforementioned facts, I am of the view that a report should be sought from which court? Which is that court? Trial court. Court. So court in so and so case regarding the status of the trial and the time likely to take for completion of the trial. Leave the matter of 3 weeks.
It may listed after lordship may listed after puja vacations.
Puja vacation. After puja.
I'm extremely sorry, your lordships. Item 13 could not be reached in time.
Which one, sir?
Item 13, your lordships.
12 o'clock. 12 o'clock, pass. Yes.
Item 16.
May I please, Lordship? Lordship, see the last order, Lordship. The last application, Lordship directed to produce the case diary.
Case diary. Is there?
Yes. Here it is the case of 302, Lordship.
You are in custody since?
Custody since 18/2/2020.
18/2/2020.
2020.
Yes.
Lordship.
Yes.
With the allegation of 302, Lordship.
What are the allegations?
Allegation, Lordship. With the allegation of file.
I will read out one statement only. ମୋ ନାମ କୁମାର ନାୟକ 17/2/2001 ଆପଣଙ୍କୁ ଦେବାର ମୌଖିକ ମାନ ଏହି ଯେ ଆମ ପାଖରେ ନରସିଂହ ପଲ୍ଲୀ କେନାଲ ପାଖରେ ବନିତା ନାୟକକୁ ବାହା ହୋଇଥିବା ଇଣ୍ଡିଆନ ଖାନ୍ ତାହାକୁ ଭଲ ଭାବେ ଜାଣେ। ସନ୍ଧ୍ୟାବେଳେ ଟ୍ରାକ୍ଟର ଚଳେଇ ଆସିଲେ ତାର ମୋର ମିଶି ଆମ ଦାସ ମାଇକି ଛକରୁ ଚାଲି ଚାଲି ସବୁବେଳେ ତାଙ୍କ ଘର ପାଖକୁ ଯାଉ। ସେହିପରି 16/2/2020 ରାତ୍ର 10ଟାରୁ 10:30 ହେବ ଇଣ୍ଡିଆଜ ମୋର ଚାଲି ଚାଲି ଘରକୁ ଯାଉଥିଲୁ। ମୁଁ ଆଗରେ ତାର ବାଇସାଇକେଲ ଧରି ଆଗେ ଆଗେ ଯାଉଥିଲି, ସେ ପଛେ ପଛେ ଯାଉଥିଲା। ଦାସ ମାଇକି ଛକ ଏବଂ ନାରାସିଂହାପଲ୍ଲୀ ଛକ ମାଝି ମୁଖ ରାସ୍ତାରେ କଲବଟ ପାଖରେ ସେ ହଠାତ୍ ମରିଗଲି ବୋଲି ଚିତ୍କାର କଲା। ଏହା ଶୁଣି ମୁଁ ପଛକୁ ଅନାଇ ଦେଖିବାରେ ଆମ ଦଶମାଇକି ଛକର ବଳି ସନ୍ତୋଷ ନାୟକ ପିଟିସନର ନାୟକ ତାକୁ ଏକ କାଠ ବାଡିରେ ବାଡାଉଛି ଏବଂ ତଳେ ପଡି ତା ମୁଣ୍ଡରୁ ପ୍ରବଳ ରକ୍ତ ବାହାରୁଛି। No, my lord, he has not been examined.
Wait. The petitioner is agreed by the order dated 20th December 2023, whereby his bail plea has been rejected. Rejected. Meanwhile, the material witnesses have been examined. Mr. Ragada, counsel for the state, has read out the statement of the eyewitness.
Only one eyewitness.
Kumara Nahako, recorded under 161 CRPC. I am not inclined to enlarge the petitioner on bail at this stage. However, liberty is granted to the petitioner to renew his bail plea after recording of the evidence of the eyewitness named above. Eyewitness with this liberty, the petitioner.
Yes. So one thing more, Lordship. If in the meantime the said witness has been examined, Lordship granting liberty to the law and trial court consider the application without influencing the order. Without influencing possible.
I have said at this stage. And if such application is moved, the trial court shall consider the application on merits on the basis of the evidence available on record. By then, without being influenced by the earlier law.
All right.
Yes.
17.
My lord, I am in custody since 22 October 2023.
22.
My lord. And for the offense under section
Friend contacted my lord, but notice not made sufficient, my lord. And that reason,
By
my lord,
order dated, by order dated
my lord,
23.
the-
I believe
my lord, the issue opposite, notice issued to opposite party number 2, return unserved.
undelivered with
Insufficient
an
address.
insufficient address.
No, that is through IO, through IO, I told.
My friend-
My lord, I have contacted with the IO. He sent the case diary and he has repeatedly gone to that house, but he was absent. She was absent. So within my lord, next week,
Once you have
my
to
lord,
go, is it
my lord, your lordship may take up this matter next week. In the
By
meantime,
order dated 23/8/2024, this court had directed to serve opposite party number 2 through the IO of the case, present case. IO has IO could not serve the opposite party number 2 as yet. By way of a last opportunity, matter is urgent to next week. It is made clear that the IO shall file a report in this regard. Somebody in the jail, you should
my lord,
understand.
I have also instructed. You send that complaints report. No, no, I have sent. I have told him that you send this complaints report along with that case diary. Only he has sent the case diary, but the complaints report has not sent.
Yes.
Obliged.
It's not did this one. Okay. Okay.
90.
Yes.
Please, your lordship, my lords. Yes, I'm in custody since 27/9/2023, my lords.
27?
27th September 2023.
Yes, sir.
Initially, the case was registered under section 498A, 302 and 34 of the IPC.
Yes.
Now, in the meantime, my lord's charge sheet has already been filed under 498A, 306 and 406 of the IPC. my
Your
lords.
husband?
I am the husband, my lords. Now,
Yes.
if your lordship sees the, my lords, the statement of the witnesses, my lords, it is clear, my lord, that she consumed poison, my lords. And I've also got the, my lords,
Medical.
the post-mortem report, my lords.
She consumed or you administrate. That's it. That's the only thing I want to see.
My lords, from the statement,
Show
my
me
lords,
something that from
let-
where I can get that she has consumed herself.
my lords, I'm placing the statement.
Relevant part. No, we read relevant part. I don't need.
I'm just reading out the statement of the informant, my lords, who is the brother of the deceased.
Read the relevant parts.
My lords, I'll just read. Yes. ଜ୍ୱାଇଁଙ୍କ ନିର୍ଯାତନା ଫଳରେ ମୋ ଭଉଣୀ ବିଷ ଖାଇ ଦେଇଥିଲା।
ବିଷ ଖାଇ ଦେଇଥିଲା।
ଖାଇ ଦେଇଥିଲା।
Yes.
One statement, my lord. 11-10 ପାଖାପାଖି ହେବ ମୁଁ ଘରେ ଖାଇ ବସିବା ସମୟରେ ଆମ ଗାଁରେ ଦଣ୍ଡପାଣି ନାଗି ଆସି ଡାକିଲା କହିଲା ଯେ ମୋ ମିସେସଙ୍କ ଦେହ ଖରାପ ଟିକେ ଆସ ହସ ଖାଇ
ଖାଇ ନା ଖାଇ ତ ହୁଏନି ନା ଖାଇ ଠିକ right petition education the statement of the informant and the family members recorded under 161 CRPC was read out extensively all of them have consistently stating that there was the relationship between the petitioner and his wife was going through a rough phase. They were quarreling off and on, and the wife of the petitioner has consumed poison. Resultantly, she died in the hospital. After investigation, charge sheet has already been filed on 24/11/2023. The petitioner is in custody since 27/9/2023. Regard being had to the period of custody and nature of acquisition, I'm inclined to.
One lakh, my lord, the cause of death would be due to poisoning. It is complication. However, viscera preserved.
The medical evidence also indicates that the cause of death could be due to poisoning. However, the viscera report has not yet been made available. See that the upper level.
I'm grateful.
120.
May I please? In this
Yes.
case, my lord, that's it submitted under section 493/306, my lord.
Custody.
Yes, my lord. And yeah, deleted the offense under section 3.
Tell me the custody first.
Custody, my lord, since 20th February 2024.
20 February
2024. And charge sheet submitted 20 April 2024.
20th April
2024.
24. Okay.
On last
What
occasion,
are the
my-
offenses?
493/306, my lord. 313 has been deleted in the charge sheet, my lord.
Okay.
On last occasion, your lordship
Death
wanted
by?
to, my lord,
Death by
committed suicide, my lord.
hanging.
Yes, my lord. On last
So-
occasion, what your lordship directed to file the charge sheet. I have filed the charge sheet, my lord.
Show me that.
In the
portion.
charge sheet, my lord, the statement of one Bharat Das, my lord.
Hmm.
May I place that statement?
Yes,
my lord? Yes, my lord. एबार मोर बयान ए कि जे आज 6/2/2022 सकाळ 8:30 रे
Loud, loud, loud.
आम ग्रामर भैरव सिंह माझी द फादर ऑफ द डिसीज माय लॉर्ड आम घर को आसी कहला जे तार झियो उर्मिला माझी घरर दुलाम रे एक टावल द्वारा फांसी होई मरि जाइछि एही खबर सुनिया परे मु घटनास्थल को जाई देखिली जे उर्मिला माझी घरर दुलाम रे गोटिए टावल रे जाई फांसी होई मरि जाइछि बेकर बांधी अन्य मुंड को दुलाम रे गोटिए बांधी फांसी होई मरिछि
That
That
is
is
true,
the-
my lord. But in fact, my lord, the
suicidal note is there.
suicide note is there, my lord. She committed suicide.
What
But,
it is?
My lord, the
Suicide note?
Suicide note, my lord, she has the petitioner having relationship with the
Mo-
deceased. Thereafter, he denied for marriage.
ବାପା ମା କ୍ଷମା କରିବେ ମତେ ମରିବାକୁ ଇଚ୍ଛା ନଥିଲା କିନ୍ତୁ ମରିବାକୁ ବାଧ୍ୟ ହେଲି ତମର କିଛି ଭୁଲ ନାହିଁ ଦି ପିଟିସନର ଦୁଇଥର
She
Pregnant
says that ତମର କିଛି ଭୁଲ ନାହିଁ।
ବାପା ମାଙ୍କର ଭୁଲ ନାହିଁ
ଆଚ୍ଛା।
ପିଟିସନ ଦୁଇଥର ପ୍ରେଗନେଣ୍ଟ କରି ଛାଡ଼ିଦେଲେ ତାଙ୍କ ଲୋକ ସମସ୍ତଙ୍କୁ କହିଲି କି କିଏ ଥରେ ବୁଝିବାକୁ ଚେଷ୍ଟା କଲେନି କି କାହାକୁ ଭଲ ପାଉନି ବୋଲି କହି ମିଛ କହି ମତେ ଭଲ ପାଇଲେ ଆଉ କାହାକୁ ଭଲ ପାଉନି ବୋଲି ଆକୁ ଭଲ ପାଉଛି ବୋଲି କହିଲେ ଭଲ ପାଇଲେ ଦି ଜଣ ବାହାରିଲା ପରେ ସୁସାଇଡ୍ କରିଛି after marriage, my lord.
After marriage, he was having relationship with someone.
Another let for that is committed suicide.
493
ପ୍ରତିଟି ମୁହୂର୍ତ୍ତରେ ମତେ ଏବେ ତାଙ୍କ ଗାଁର ଝିଅକୁ ଭଲ ପାଉଛନ୍ତି ଆଉ ଜଣେ ଝିଅକୁ ଭଲ ପାଉଛନ୍ତି ଏବେ ବି ଆସି ରାତ୍ରରେ ହେଲେ ମତେ ଫୋନ ବିଜି ରହୁଛି
Submitted and she alleged that, my lord, the 313 allegation has been deleted in the charge sheet. my lord.
due to combined effect of anesthesia
That is there.
followed by
She has committed suicide, there is no
And,
doubt.
yeah.
That is an emotional issue.
Regarding 313 allegation, my lord, in the charge sheet that has been deleted, my lord. 313 no allegation is there.
What are you doing?
I would have
ହଁ।
ଆଜି 23/3/2021 ଆପଣ ନିକଟ ଦେବାର ବୟାନ ଯେ ମୁଁ ଜଣେ ସାମାଜିକ କର୍ମୀ ହୋଇଥିବାରୁ ଆମ ଗାଁ ଅଞ୍ଚଳରେ ସୁବିଧା ଅସୁବିଧା ସାହାଯ୍ୟ କରିବ ଉର୍ମିଳା ହେଉଛି ସାନ କାଇକିଆ ଗାଁର ଭୈରବ ସିଂଙ୍କ ମାଝୀଙ୍କ ଝିଅ ସେ ପାଠ ପଢି ଘରେ ରହୁଥିଲା ଶର୍ମିଳା ଗୁଡାର ଲାଲକୃଷ୍ଣ ପାଣ୍ଡେ ଭୈ ସିଂର ଦୂର ସମ୍ପର୍କୀୟ ଭଣଜା ଲାଗିବ ସେ ତାଙ୍କ ଘରକୁ ଯିବା ଆସିବା କରେ ତାଙ୍କ ଦୂର ସମ୍ପର୍କ ହୋଇଥିବାରୁ ତାଙ୍କ ଘରେ ରହିଲେ ମଧ୍ୟ ରହିବାକୁ କେହି ବାରଣ କରନ୍ତି ନାହିଁ ଗତ 4 ବର୍ଷ ତଳେ କୃଷ୍ଣା ପାଣ୍ଡେ ଉର୍ମିଳାଙ୍କ ମଧ୍ୟରେ ପ୍ରେମ ସମ୍ପର୍କ ଗଢି ଉଠିଥିଲା ଏ କଥା ଉର୍ମିଳା ଘର ଲୋକ ଜାଣି କେହି ଜାଣିନଥିଲେ କେବଳ ଉର୍ମିଳାର ସାଙ୍ଗ ସୁଭଦ୍ରା ଜାଣିଥିଲା ଉର୍ମିଳା ଯେବେ ଆତ୍ମହତ୍ୟା କଲା ସେ ନିଜ ହାତରେ ଲେଖା ଚିଠି ଛାଡ଼ି ଦେଇ ଯାଇଥିଲା କୃଷ୍ଣା ଯେବେ ରାତିରେ ଉର୍ମିଳା ଘର ରୁହେ ସେମାନଙ୍କ
Should be at least about 6 months. Okay.
Let's say for an adult.
As per request.
22
In this case, prisoner's petition has come in my name, but unfortunately I could not file the Vakalatnama. Today I am filing the Vakalatnama.
Want to file? Let us consider for the petition 6.
I have already filed all the documents, my lord. Depositions also there.
File Vakalatnama on behalf of the petitioner as he has been recently engaged. Vakalatnama is taken on record, leaves the matter after 1 week.
Monday, my lord, or 9th.
He leaves it. This is not those matters where it will be urgent to November. It is
Custody
only
since,
as early as possible.
Custody since 12/2023.
Yes.
23
Yes.
23 and item 26 were taken up together.
23 and 26.
Yes. Carrying out of one affair.
city not there city was staff guarantee 26 item my
Yes.
friend will support
26.
Well, let it be taken up in item 26.
26.
matter 26
Wait. 25. 24.
24, may I please, my lords?
Yes.
My lords, I'm incarcerating since 5/6/2023, my lord.
5/6/23. Okay.
My lord, charge sheet has been submitted on 25/9/2023.
25/9/2023. Okay.
Allegation under the, my lord, 302/34 and 120B of IPC, my lord. On last occasion, your lordship has heard this matter, my lord, where the statement of informant.
Yes, my lord. Though my friend, my lord, given the police papers, my lord, But in fact, case diary is not available to me, my lord.
My lord counsel for the state, Mr. Raghunath states that
Case diary?
he has not yet received the case diary. Leaves the matter up to about 1 week. Meantime, case diary may be called for.
My lord, already on the last occasion, there was a
Wait,
small.
There are 3-0 case without case diary, I can't do it.
Okay.
Yes.
My lord has fixed to.
He's giving a date.
Grateful.
25 years.
May I please go to you? My lord, I'm the husband, my lord. I'm in custody since 10/2/2024. My wife
10
consumed
to 10
2/2024.
24, okay.
Yes, my lord. My wife consumed poison. Then she was rescued and taken to the hospital by me and my family
Offenses?
member.
What are the offenses, sir?
Offenses, my lord, 498A, 304B, 34.
498A.
Yes, my lord.
Yes.
And
304B.
yes, my lord.
Not 306. Charge sheet has been filed.
Charge sheet has been filed.
What are the charges? Sir?
Charge sheet, my lord, 306 is added. That has been filed on 7/6/2024.
The same year.
Hello.
Period of custody is late. 9. Just Mr. Mishra was arguing the same issue.
Same, ma'am.
9.
My lord,
Stay for some time. I'll give.
My lord, I have filed the charge sheet.
You file the charge sheet here.
Yes, my lord. May I read, my lord, part of the charge sheet. I have written the certified copy of the charge sheet.
Please file it on 9th I'll take up.
Okay.
9th I'll take. I want that you will be getting bail, but stays at least 6 months above, roughly.
More than 6 months, my lord.
Therefore, I am putting it on 9th of this October.
Yes, ma'am.
Yes.
26.
May I please, my lord? My lord, item 23, my lord. The petitioner is.
I'll just come and.
Yes, yes.
Just one. Well,
7/23, my lord.
okay.
And the fact is, my lord, the deceased was the aggressor, my lord. And on the date of occurrence, while the deceased was having cultivation field, my lord, the cattle trespassed into this and damaged the crop, my lord. And the petitioner in item 26, my lord, he opposed.
Hmm.
And the deceased, my lord, assaulted him and came with a pistol to fire. And
He came with a pistol.
yes, the deceased came with a pistol to fire, my lord, but did not fire, my lord. The quarrel ensued. And the wife of Nanda alias Sushanta Naik, her name is Pushpalata Naik, was released on bail, my lord. he went to the deceased for compromise. And in the house of the house of one Tungi alias Dibos Naik, my lord, he assaulted the deceased by means of a axe, my lord. He gave first blow. Then allegation against one of these petitions, my lord, they combinedly assaulted the deceased, my lord. There is no
23 and 24, both of
26,
them combinedly
my lord.
attacked.
Both all persons are
And I
assaulted.
am reading the statement, my lord.
I know, I remember the lady I granted.
And
bail.
only lady is granted because your lordship considered that she has two minor child. But your
that's
lordship
true.
also reflected in the order. That
Yes.
she has, and leading to discovery, one cottage was also seized from the lady. And
That
from
lady.
spot, my lord,
How
10
many
was seized.
witnesses are there?
My lord, 4 eyewitnesses are there, my lord.
They have not been examined.
No, no one.
My lord, so far is
My lord,
the
charge sheet was submitted on
item 26, my lord. He the husband of the accused released on bail, that is Pushpalata Nag, my lord. And this he is
No,
the
there is
husband.
direct allegation against this. I remember that
Lady.
deceased was a history cheater.
Yes,
My
yes, my lord.
And he came with a revolver.
Revolver, yes.
And these two people
No, no,
assaulted him.
there
and-
are-
Assaulted him, my lord, there are gone, Kotturi, it was seized.
And the wife of one of the accused who has been granted bail, she only called this accused to her house or something.
No, my lord, to whom bail was granted, Kotturi was seized from the her, my lord.
Her.
And though your lordship only considered that she is a lady and having a minor child.
two children.
But eyewitnesses are there leading to
So
discoveries there.
you wait till the eyewitness. I am giving you that.
My lord, you also can see, my lord, this petition, my lord, item 26, my lord,
Hmm.
is the husband of the lady was released on bail. So entire members in custody, my lord. The 4 brothers and the wife has been there in custody, my lord. So only wife has been released, this petition has been released on bail. So for my lord, my assumption that
But there is specific role against these people.
no, not my lord. Only allegation against my lord, omnibus in nature, my lord. No weapon of
No,
offense.
you have you and the other guy has beaten up,
All are assaulted.
assaulted.
All are assaulted.
No, first assault was given by what Tungi alias Dibos Naik. That's the cause of death, my lord. And other combined assaulted by means of weapon, by holding weapon offense.
There are multiple injuries in the body.
There are, my lord, some,
On the face and slab, there is injury, there is fraction of vital organ, my lord.
What? How many witnesses you said?
My lord, 31 witnesses are there.
Total.
Total. And the rejection order was, my lord, 2011-23. Charge sheet was submitted on 4/11/23.
No. How many witnesses have already been examined?
My lord, there is no.
And how many eyewitnesses?
My lord, 4 eyewitnesses are there.
Let the 4 eyewitnesses be examined. I'm giving you some time.
And you also may at least consider the Sushanta Naik, the wife, his wife has released on bail.
No, he has direct allegation.
26 and 23 and 26. The petitioner is agreed by petitioner is agreed by order dated. I am giving the dictation of 26 and 26.
23.
Order dated. Rejection order dated.
My lord, that is order dated 2011-23.
2011-2023, whereby the bail plea of the petitioner has been rejected. Bail plea of the petitioner has been rejected. Mr. Bishwal, let me counsel for the petitioner. Mr. Rautrai, let me counsel for the petitioner. Submits that the co-accused has already been granted bail, and he tried to draw parity with the co-accused who has been enlarged on bail. The co-accused was enlarged on bail, being a lady and having 2 minor children. The allegation against the petitioners are the evidence against the petitioners are serious in nature. There are allegedly 4 witnesses, eyewitnesses to the occurrence. Therefore, I am not inclined to enlarge the petitioner on bail. However, liberty is granted to the petitioner to renew the bail plea after the 4 eyewitnesses are examined by the court below. The trial court is directed to record the statement of the examine the eyewitnesses preferentially over the other witnesses. If for any reason whatsoever the eyewitnesses could not be examined within 6 months, the petitioner has the liberty to renew the bail plea. Both.
26 verse 7.
Yes.
27. Offense, my lord, 302 IPC. It's under custody, my lord, 8/5/22.
8/5/22.
Charge sheet submitted, my lords, 9/7/22 against 3%, my lords.
9/7/22.
Against 3%, my lords. That one Pinto Mollar, Videshi Mollar, and against this petitioner. Here, my lord, petitioner was not named in the FIR, no eyewitness of the occurrence, my lords. Only basing the statement of the co-accused person Pinto Mollar, my lord, petitioner implicated, and as per the statement of the
What
Pinto.
is the role of
My
this?
lord, FIR was lodged against the unknown persons. Subsequently, my lord, the leading to discovery, lathi and bloodstain stone. It was
Whose statement leading?
Pinto Mollar.
My lord, that was seized from the co-accused, my lord.
Pinto.
Yes. And my lord, the reason is that due to quarrel to drink handia. There is two witnesses who is that is post-occurrence witness is there and pre-occurrence witness is there. I'm reading the post-occurrence.
What is the role of this man? What is his?
My lord, all are
his
assaulted.
path?
All are assaulted. My lord, I'm reading that post-occurrence statement, my lord, which 164 statement was recorded.
164 of?
Pinto one.
That no. Kundra Munda, my lord.
Kundra.
Kundra Munda.
Kundra.
ଯେ ମୁଁ 4/7/22 ତାରିଖରେ ଉପସ୍ଥିତ ସତ୍ୟ ବୟାନ ଦେଉଛି ମୁଁ ଘଟଗାଁ ବାଡ଼ି ଗୋଟେ ଘରକୁ ଆସିଲା ବେଳେ ରାସ୍ତା କଡ଼ରେ ଦେଖିଲି ଗୋଟେ ଡେଡ୍ ବଡି ପଡିଛି ତା ପାଖରେ 3 ଜଣ ଠିଆ ହୋଇଥିଲେ ସେମାନେ ହେଲେ ପିଣ୍ଟୁ ବିଦେଶୀ ରଞ୍ଜିତ 3 ପିଟିସନର୍ସ
They were standing.
ହଁ
Yes.
ନିୟର ଦ ଡେଡ୍ ବଡି ମତେ ପିଣ୍ଟୁ ଗୋଟିଏ ପଥର ବଡ଼ ପଥର ଧରିକି କହିଲା ତୁ ଏଠୁ ପଳା ନହେଲେ ତତେ ମାରିଦେବି ମୁଁ ଡରିକି ପଳାଇ ଆସିଲି ତାପରେ ଜାଣିଛି ଯେ ମୃତଲେଖ ହେଉଛି ନବୀ ଆମ ଘର ପାଖରେ they were standing near the dead body with his and that stone was also recovered my lord.
Pre-occurrence.
Pre-occurrence, my lord, our statement also, my lord, 164 statement that is the Jamaki Liangi Jamaki Liangi ଯେ ମୁଁ ଦେଖିଲି ଯେ ଆଜି ହାଣ୍ଡିଆ ବଜାରରେ ରବି ପାତ୍ର ସହ ପିଣ୍ଟୁ ମହରା ବିଦେଶୀ ମହରା ରଞ୍ଜିତ ପାତ୍ର ପାଟିତୁଣ୍ଡ କରୁଥିଲେ
Wait, these two witnesses
My lord, ମୁଁ ସେମାନଙ୍କୁ
the petitioner is agreed
They have
the
not seen
order dated 4/3/2024 whereby his bail plea has been rejected. Subsequent thereto rejected. Although there are no direct evidence against the petitioner, but there are strong circumstances indicate strong circumstances cited against the petitioner by the prosecutor. Two witnesses have been the statement of two witnesses, post occurrence and pre-occurrence witnesses were recorded under section 164 CRPC.
Right.
164 CRPC. The statements were read over at the bar extensively. I am of the considered view unless these witnesses are examined, the petitioner is therefore I am not entitled to enlarge the petition on bail. However, liberty is granted to the petitioner to remove the bail plea after the examination of the two witnesses whose statement under section 164 CRPC has been recorded by the police. The trial court is directed to do well to see that the statement of the said witnesses are examined preferentially over the other witnesses.
May I submit one thing, then?
Yes.
As per that Pinto Mollar statement, co-accused statement, there was quarrel between the deceased and my lord, the Videshi Mollar. And Videshi Mollar, with the help of the one stone, my lord, hit to his chest and head. So, my lord, that this is clearly mentioned, my lord.
See, nobody has seen the incident.
No,
Pre-occurrence and post-occurrence, you were present.
May I submit?
Why were you standing there? Post-occurrence, near the dead body.
And also straighten that
submitted the
pre-occurrence also you were there.
Pre-occurrence, my lord, the Kandra Munda also, my lord, the seen the occurrence, my lord.
Whatever. After examination of these two witnesses, you will get the bail. Yes. 28. 28.
Please, your lordship.
Yes.
Accused in custody since 14/10/2023.
14/10?
2023, my lord.
14/10. Okay.
And the charge sheet has been filed on 9/3/2024.
Yes.
And the
9/3/24.
My lords.
Okay.
The allegation under section 306 and 498 A IPC, my lords.
306.
My lords.
You are in custody since 14. Okay. Yes.
My lords.
Husband, your husband.
My lord.
Husband.
Yes. What is the allegation?
Though matter FIR was lodged against the petitioner and in-laws, but only charge sheet was submitted only against the husband. That was
306.
my lord.
That's it, yes.
Charge sheet submitted under section my lord 302, 498A and 34.
No, my lords.
302.
My lords, sir. After
Later,
that, it was
28.
on first charge sheet was filed, my lord, on 9/2/2024. Thereafter, subsequent, it was converted to 306 by in 9/3/2024. I have the charge sheet, my lords.
No.
First, it was for charge sheet
FIR was 302.
302.
Okay.
Thereafter,
And charge sheet is filed 306.
306.
Okay,
First,
fine.
it was filed in 302. Thereafter, after further
Yes.
investigation, it has
Yes.
been converted
Yes,
to 306.
that's
Then my lord, PM report is that asphyxia due to antemortem hanging. That is also no injury.
Okay.
And a petitioner also staying separately with the deceased in a separate mess. Therefore, the in-laws were not attached as an acute my lord. They were discharged.
Petitioner was staying with the
With his
Then
wife.
how she died? Hanging.
Hanging
What are
antemortem.
My
the-
lord, directly hanging, but I am only, your lordship, I will give the statement of one villager, my lord,
Hmm.
who was present at the time of occurrence.
No, there is no witness to occurrence, my lord.
ମୁଁ ଟ୍ରିଟମେଣ୍ଟ ପର୍ସନ ମାଇଣ୍ଡ ଯେ ବିବାହ 9 ବର୍ଷ ତଳେ ହୋଇଥିଲା ମଝିରେ ମଝିରେ
They
ତାଙ୍କ
are quarreling and all these things must be there.
ସ୍ୱାମୀ
It's
ସ୍ତ୍ରୀ
not
ଭିତରେ
fixed.
ପାଟି ହୁଏ
How she died?
ମାନେ
That
died
day
was
what-
due to hanging my lord.
Hanging, I know, but what happened on that day? Any immediate
My lord, therefore I am reading that
that
statement.
part?
ଯେ ଉଷା ଭାବ ଯୋଗୁ ତାର ଶାଶୁଘର ଲୋକମାନେ ସ୍ୱାମୀ ଦେଢଶୁର ଦିଅର ମାନେ ଯୌତୁକ ନିର୍ଯାତନା ଦିଅନ୍ତି ଏଇ ବାବଦରୁ ତାଙ୍କ ଆଗରେ ତାଙ୍କ ପରିବାର ମଧ୍ୟରେ ବୁଝାସୁଝା ହୋଇ ଆସିଛି ଆଜି 14/10 ତମେ ଲିକ ସକାଳୁ ତାଙ୍କ ଘରୁ ପାଟି ଶୁଭିଲା ଏବଂ ସଙ୍ଗେ ସଙ୍ଗେ ମୁଁ ଯାଇ ଦୌଡ଼ି ଯାଇ ଦେଖିଲି ଯେ ତପନ ପୃଷ୍ଟି ତାଙ୍କ ସ୍ତ୍ରୀ ବେକରେ ଲୁଗା ଦେଇ ମାରି ଯାଇଛନ୍ତି ବୋଲି ଚିଲଉଛନ୍ତି ଆମେ ଯାଇ ତାକୁ ହଜବ୍ୟାଣ୍ଡ ସେ ମରିଯାଇଛି ବୋଲି ଲୁଗାରେ ମରିଯାଇଛି ବୋଲି
ତପନ ପୃଷ୍ଟି କଣ ହେଲା?
ତପନ ପୃଷ୍ଟି ତାଙ୍କ ସ୍ତ୍ରୀ ବେକରେ ଲୁଗା ଦେଇ ମରିଯାଇଛନ୍ତି ବୋଲି ଚିଲଉଛନ୍ତି ଏହାପରେ ଆମେ ଯାଇ ତାକୁ ଦେଖିଲୁ ସଙ୍ଗେ ସଙ୍ଗେ ଆମେ ତାକୁ ସିଙ୍ଗାପୁର ଡାକ୍ତରଖାନାକୁ ନେଲୁ ଡାକ୍ତର ମୃତ ଘୋଷଣା କଲୁ that is also no injury on the body my lord. So assault part is not there.
Right. Petition is accused in FIR also under section 4. Allegation against the petitioner. So you read over whose statement is that?
My lord, that is the Suresh Prusti my lord, villager, one of the village.
Read over the statement for one of the independent witnesses, Suresh Prusti, recorded by the police under section 151 CRBC, who literally have stated that on 14/10/2023, when he heard the shouting from the house of the he immediately went there and saw that the wife of the petitioner hanged herself by tying her neck in sorry, immediately the wife of the petitioner was rescued and taken to the hospital where she died. Repeat next petitioner is in custody since 14. Initially, although the FIR was registered under section 302 and 498A CRPC against the petitioner and entire family members. However, after investigation, charge sheet has been filed under section 306 and 498A 498A. I read with 4, section 4.
No matters. Only 306, 498.
IPC against the petitioner only exonerating the entire the other family members of the petitioner. Petitioner is in custody since 14/10/2023 regarding head to the period of custody and nature of allegation granted bail. Yes. 29.
May I please let?
Yes, madam.
Already the petitioners are acquitted in the trial court.
Acquitted.
Again.
Okay, thank you very much. Acquitted. In
The
practice.
matter-
Permitted to withdraw, my lord. Already judgment was passed, madam, in both the cases.
Both 30. Yes. 31.
31. Please, my lords.
The petitioner is behind bar since 19 December 2023, my lords.
Yes.
Charge sheet was submitted on 28
23, December 23.
19/12/2023. Charge sheet was submitted, my lords, on 28/12/2023, my lords.
My lord, here CD required, my lord, because
Lords,
an IT Act is there. CD is not
admitted, my lords, but may I submit, my lords? In the charge sheet, 9 witnesses were cited. In the meantime, my lords, 7 have been. I'm supplying the true copy, my lords. None have supported. Moreover, all the punishment, all the offences alleged, none of them traverse the periphery of 7 years, my lords. None of the witnesses have supported
Who
the
are witnesses?
in the mother of the victim, the brother, the informant, everyone has been.
What are the victims?
Victim has not been examined, my lords. I have supplied the copies fairly, my lords.
Victim
It
is
is a
not
case.
victim.
It is a case of there where
Your lordship
no
targeted
sexual-
that only 2 witnesses are there. Your lordship directed
behind
to-
bars, my lord. The problem is it is not a case of sexual assault or something, my lords. It is alleged that the present petitioner created fake ID.
354,
My lords.
354D.
My lords, he
354D.
created, I'm submitting, my lords, he created certain fake ID on different social media platforms and thereafter circulated photos. Those are not nude photos also, my lords. In her photos, admittedly, and wherein he had cited certain remarks, my lords. Those are derogatory remarks, admittedly, my lords. But those were also not even supported in the court, my lords, by even the mother of the victim, so also my lords.
She is a 24-year-old boy. Parent, which part you want to read?
My lords,
Just give a copy to him, pass over. Give a copy to him.
I'm supplying.
See,
I'm supplying the copy.
1 minute. The allegation is she has taken some photograph, not nude photograph. That's what he says. Not nude photograph.
With
and
some
circulated-
objectionable remarks.
Circulated with remarks.
Objectionable remarks, my lords.
Remarks. Whether the victim is examined or no examined, if it is circulated, the other family member might have seen it. What the family members are saying,
It was
just see and tell.
it was uploaded in the Instagram. That is the.
I will pass you. If it is the family member says that not supporting the prosecution, even the prosecutor says is neither here nor there because it is not a sexual intercourse.
No, there is no sexual.
It is only whether just check it up. Huh? I'm just passing.
Minor.
Yes. Yes, compromise matter. Which one?
Item 1.
Okay. Yes. Mr. Raghunath, just see.
What happened in this case, my lord? I think, my lord, it cannot be, my lord, since compromise, but after conviction, my lord, how can this court, my lord, to my lord? They have been convicted, my lord.
Convicted for which of
The offense, my lord, 307. They have to, my lord, approve the appellate court there, my lord.
Do you have any judgment?
My lord, yes. Judgment.
I think after conviction, my lord.
After conviction.
And when appeal is pending, you can do it.
Appellate court.
When appeal is pending before appellate court, you can do. I have been doing it.
Yes, my lord. One thing, my lord. So far the item 1 is concerned, appeal is pending. Let that with that liberty appeal may be disturbed. Then, secondly, my lord, that as other papers or other as concerned, they have problem.
No, the same FIR.
Same.
They were absconding. That's the problem.
They are not absconding, my lord. The FIR against the unknown, my lord. They are like the PT. FIR against the unknown persons.
I know everything, but somehow there are 2, 3 accused, whatever. How many accused are?
3 accused.
3 accused persons. 2 of them have faced the trial.
Yes, my lord.
And they were convicted.
One convicted and one
acquitted.
Acquitted.
Okay. That conviction, against that conviction, appeal is like pending. And insofar as the second petition is concerned, this gentleman was absconding.
Yes, ma'am.
Absconding. And if there would have been an acquittal, I can understand. The appeal is pending. How can I quash it and exercising 482? That this court can support.
Specific matter.
Let us see. So, which paragraph, sir? Which paragraph? Even after conviction, I can do it.
I am reading, my lord, one judgment, my lord. 14 Supreme Court, case 4/6. My lord,
2014.
My lord. Read one paragraph. Where the prosecution evidence is almost complete or after conclusion of the evidence, the matter is at the stage of argument or normally high courts should not refrain from exercising power under 42. In such cases, the trial court would be in the position to decide the finally merit of the conclusion.
One thing, pass over. Settlement.
Yes, sir. Party form.
Yes, sir. What are the offenses?
376, 6 POCSO, another offense.
Yes.
The victim married to another person.
So in the meantime, victim has married another person.
What was the, so many accused persons? That's all. The mother, let the mother come.
I have to say Pune dispose of it.
Yes.
26. Put up this matter next week for complaint.
363, 366, 294, 34 of IPC, my lord. 34 of IPC, my lord.
Parties are there.
My lord, both present, my lord.
21. They married.
Married.
They are married.
Petitioner already got married. Victim girl.
Victim girl. Yes.
90. It is 90.
96.
Ranjan Jena. And Madhuspita.
Pandit.
Sanjay Kumar Pandit.
Sanjay Kumar Pandit is Bappa. Bappa notice already go, but he did not come. Bappango notice.
He is the informant.
Yes, my lord. Notice he as soon as informant go notice.
Then again, he may have an objection tomorrow because he is the informant. I'll record their statement. Let the girls next date of hearing. Bring the father. Right. At the instance of opposite party number 2, the FIR number 4 came to the register against the petitioner. Petitioner. Allegation against the petitioner. The charge sheet has been filed.
That's it.
Charge sheet. Charge sheet filed. You don't know. Right. Investigation in the case is still going on. At this stage, the petitioner submits that he has already married with the victim girl, and he has placed on record. What is this certificate?
Notice certificate.
No. This is what is the Lakshminarayan Mandir?
Lakshminarayan Mandir is a
Who has given them the authority to issue certificates like this?
Mandir authority, my lord.
My lord, may I pray one thing? My lord, your lordship may take up this matter after launch, my lord. I will verify that.
No, but I am surprised. This Lakshminarayan Mandir also started giving certificates.
Marriage certificate.
That is not valid. What kind of certificate is this? You are multiplying your offenses.
Mandir se bahai chindu gili vivahar tarikh 2/2/2024. Rasid number they Rasid.
Usually, my lord, they are married in one temple. Thereafter, they applied for
Rasid.
special marriage.
See, registration after solemnization is something different.
Marriage certificate. Rasid ଦେଇଛନ୍ତି।
ରସିଦ ଦେଲେ ବାହା ହେଲେ ନା
ବାହା ହେଇଛନ୍ତି ବୋଲି ଗୋଟେ ରସିଦ ଦେଇଛନ୍ତି।
that is not admissible.
ବାହା ହେଲେ କଣ ପେମେଣ୍ଟ କଲ? କଣ ରସିଦ ଦେଲେ?
ପଇସା ଦେଇଥିବେ କିଛି ପଇସା ଗୋଟେ ଡିପୋଜିଟ୍।
Where is that? You show me. You paid this much. What is received? This you are using this as a marriage certificate. Basically, that's what you have said in your petition. Why are you doing all this thing? I don't know.
The authenticity of that district is also.
That is not valid. They have decided to do something against the clients. Why are you using? You are a lawyer. Don't use this kind of in the judicial proceeding. If you use this kind of thing, you are inviting problem for your clients. At this stage, the petitioner submits that he has already married with the victim girl. The petitioner and the victim girl is present in the court. Whether they are married or not, nobody knows. Parents are not there. Neither the boy's parents nor the girl's parents. Nobody is there. And tomorrow I will quash the petition and this boy will throw away the girl.
But they must have converted to.
There should be a social sanctity
They have
to the marriage.
challenged the FIR, my lord.
FR 363, 366, 394. Must have been they converted to 376. That
marriage
So what?
They are being represented by their respective counsel.
Informant
And identified by them. They've also filed self-attested copies of the Aadhaar card. Although notice was issued to the opposite party number 2, the informant and father of the victim girl, but he is not present in the court or not represented even. The IIC of the IO of the IIC na IIC which police station? IIC Baliapal police station is directed to serve a copy of this order on the opposite party number 2. Please the matter satisfactory. On the next date of hearing, the presence of the opposite party number 2 is dispensed with. Yes.
My lord, a free copy may be given that I will communicate to the IS.
Let the girl may not come, but the boy should come. Aadhaar card may go. Okay. Come to the main list. 31.
Let's, my learned senior has gone through this.
Yes, my lord, I have checked up that. Deposition copy.
This may be kept as a part of the record.
Only she has stated that a photo was uploaded, but no one has seen that photo. And it was deleted. Subsequently, it was deleted. My
31, huh?
My lord.
You are in custody since?
Millards in custody since 19/12/2023, millards.
Right. Petitioner is the accused in FIR number so allegation against the petitioner is after investigation, charge sheet has been
charge sheet on 28/12/2023.
Charge sheet has been filed. And subsequently there too the evidence of
7 witnesses.
7 witnesses have been taken. The certified copy of the evidences recorded before the court below has been handed over to me for tenure. I have extensively gone through the evidence. It has come on evidence that although the petitioner has taken photograph of the victim girl and circulated in the circulated in the Facebook and Instagram, social media with some lewd comments, but the photographs were removed subsequently. There is no allegation in the either in the FIR or in by the statement of the witness that the petitioner has circulated new photographs of the victim. Regard being had to the fact that the evidence of the substantial evidence of the material witnesses have already been examined, and the petitioner has been in custody since 19/12/2023. I'm inclined to admit the petition on bail. Yes.
96 item. I file no pursuit action. Police खोजू जे arrest कर दोगे तो. No. बाहर रोज arrest कर दो बोले असुविधा.
What to do? Arrest बाहर
No pursuit action था.
In the peculiar facts of the present case, no pursuit action shall be taken. See, the problem with their young people, they are married. They don't realize what is happening in the world. And the parents are after this boy.
Yes, ma'am.
And police come to arrest. Even if they are married, they may lead a happy life subsequently. We don't know. If once he goes to the jail, the relationship between both of them is bound to be ruined.
Yes, ma'am. Definitely.
And this boy will keep on saying that because of you, I went to jail. So start torturing.
Till that period, madam, they will. Till that period of till crossing, they will live peacefully.
Thereafter, everything happens. I know. That is the whole difficulty. What to do?
After that, dowry allegation, torture, 490, all things.
And that 306 maybe also. We don't know. Yes. But till then, it is our duty to see that at least they peacefully live. Yes.
See their pleasures, madam.
And it's made clear that this entry order is only till next date of hearing. Not that you will go, keep on seeking adjournment. And if the next date of hearing, if the petitioner will not Next date of hearing, keep it till next date of hearing only.
May please. The petition, the married sister-in-law of the deceased milord.
Yes, custody since
Whether 23
23, 11, 23.
23,
11, 23.
23. Okay.
Milord, she is not named in FIR, milord. In the FIR, the mother-in-law, father-in-law, they have been named. On the date-
306 or 302?
No, 302.
302.
498, 302, 201 by 34 IPC.
Okay. Charge sheet is filed 302.
Charge sheet submitted 302, 498, 201, 34.
Who are you are the husband?
No, my lord.
I am
She is the sister-in-law.
Dada Sosuro.
Boro ja. Taja.
Dada Sosuro Bohu. Dada Sosuro Bohu.
Dada Susuru.
They are living jointly, my lord.
What is her role?
Role, my lord, on the date of occurrence, my lord, there is a quarrel ensued between the deceased and the mother-in-law. And she tried to, my lord, fled away from the house.
The
deceased, my lord. And thereafter, the mother-in-law, my lord, she got hold of the deceased and tried to strangulate her by means of a, my lord, sadi. And the petitioner was holding her hand. This was the allegation against the petitioner.
This is the allegation, my lord. Then, my lord, what is they have done? They have pulled the deceased to the well.
That is not, that,
my lord.
that is not there.
With that they have think that she was died. Then, my lord, they have kept some bucket and sari and soap near the well and made a halla that she was jumped to the. My lord, that present petitioner and mother-in-law.
And PM
report is, my lord, PM report is drowning, and there is also abrasion bruise that was in the, and there was also drowning is there, drowning is there, my lord. And one of the statement, my lord, villager, she also see.
306.
No, it's a case of
302, my lord. 302
is there. So for this is his concern, my lord. She is at the time of occurrence, she was holding the hand of the deceased, my lord. This was the allegation against her, my lord. So for mother-in-law concern, she had committed the murder of the deceased, my lord, and thrown the dead body to the well. In the Santosh Naik,
she got the bail, mother-in-law.
She is in custody, my lord. And this lady, my lord, she has not taken an active role, my lord. Only, my lord, she is holding the hand of the deceased on the date of occurrence.
Is it not active?
Active, but while she was going away to some other place, and she was holding the hand.
What about the husband?
Husband,
my lord, there is no allegation against the husband.
These two women only.
My lord, there is no allegation against the husband. And also, he is staying outside.
And she is also not named in FIR, my lord. This petition is not named in FIR. Subsequently, she was added.
And my lord, deceased has 2 child. That 5 years, 3 years child is there, my lord.
And this petition has been implicated thereafter, my lord, on the statement of the my lord, Apana Naik, my lord, who was stated, I'm reading, my lord.
What is she doing, this petitioner?
She's a married lady, my lord.
My lord is
she's a housewife, my lord.
Housewife, that sister-in-law, housewife.
She's a housewife, my lord. So, lady, my lord, about 20 years of age and custody since, my lord.
You have participated. Both of you have done now.
Both are participated.
Mother-in-law has taken active role as to admit, my lord. So for this, she is concerned, my lord. Only, my lord, that allegation against her there, my lord. There's no allegation because she is saying separately.
My lord, how it will be segregated? One has
she who have prevented that disease from registering by holding her hand.
No, my lord. No.
What else you need?
No.
Main accused is tying the sari in the neck. You are holding the hands up for the disease. You are preventing her to protest.
And thrown her to the well.
20-year-old and that.
My lord, preventing
both
her.
the ladies are.
My lord, preventing her not to go, my lord, outside of the house, my lord. Not that by holding her hand, my lord. And this mother-in-law committed murder, my lord. That is not the allegation against her, my lord.
That is the allegation.
No, that is not there, my lord. That is not there.
Anyway, who are the witnesses?
My lord, one of the witnesses, I am reading that Aparna Naik, 164.
How many material witnesses?
Material witnesses are 35 numbers.
35 material witnesses.
My lord.
No, those are no.
My lord, material witness, my lord, one Aparna Naik, my lord, and one complainant, and 2 neighbors.
Complainant has not seen the occurrence.
In the
Aparna
post occurrence or pre-occurrence witnesses tell me.
My lord, Aparna Naik, I am reading that portion, my lord, Aparna Naik.
164.
164, my lord. Panchali Naik.
How many witnesses you have examined? 164?
164, only one. This Aparna Naik statement was recorded.
Petitioner is agreed by the order dated 9/4/2024, whereby her bail application has been rejected by the trial court. Petitioner is in custody since 23/11/2023. Allegation I have gone through the evidence on record, which forms part of the charge sheet, and I have also peruse the statement of statement of one of the witnesses recorded under section 154 CRPC.
Apollo Naik.
Namely Apollo Naik.
She is the eyewitness also. And my lord, she is the eyewitness.
See, I am not inclined to enlarge the petition on bail at this stage, owing to the nature of allegation. However, liberty is granted to the petitioner to renew the bail plea after the eyewitness and material witnesses are examined. If for any reason the witnesses could not be examined within 6 months, hence the petitioner is also at liberty to renew the bail. With this liberty, the petitioner. Yes. 33 on APS.
33, my lord. 498A, 326A. SC data by the mother-in-law.
326.
326A.
498.
498A.
Then what is there? You see, custody since?
Only custody since 22 to 2024.
22
to 24.
Why is he not getting bail? 498 bail.
498, my lord. 326A is the
Get out.
SC data.
Huh?
SC data. But
SC
the
data.
my lord, SC
Which
data.
body part? So minor than I'll grant bail.
No, that
Face.
present petitioner is 60 years. Lady 60 years, he has thrown SC to her in-laws, my lord.
So adjourn it. Non-APS adjourn. 34.
Please, your lordship may be permitted to place on behalf of Mr. B.
Yes.
My lord, 34. Yesterday, I have received a wrong CD, my lord, which was tagged with this file. Today, my lord, I received the correct CD I have received.
Next.
Though it is a 302 and unknown affair, I will prepare. my
Next
lord.
Yes. Obliged.
35.
May I please, your lordship?
Yes.
May I please, your lordship?
Yes, Mr. Das.
In this case, your lordship, two petitioners are there. That is one Jahangir Alam is 21 years. He is the driver of the alleged vehicle, your lordship. And another year, lordship, Apu Kumar Prasad. He is the passenger of that vehicle. He is 23 years old.
Yes.
And the ganja has been seized from alleged vehicle, your lordship. That is
What is
4
the
jolly
recovery?
bags. One jolly bag is
104.
4 kg belongs to Bihar.
Custody since?
custody since
7523.
custody since 7
Seven-
2023, your lordship.
Wait, material witness. Let material witness. Right on. Petitioner is agreed by the order dated 15/4/2024. Full stop. Petitioner is an accused petitioner is one of the accused in FIR number in connection with FIR number 1. It is alleged that recovery of what is the quantity?
104 kg.
43.
104.
Kilo of ganja has been seized from the litigation. The petitioner is a resident of Bihar. Resident of Bihar. I am not inclined to entertain the present bail application at this stage. However, owing to the fact that petitioner is in custody since 7/5/2023, liberty is granted to the petitioner to renew the bail plea after the material witnesses are examined. With this observation, the petition is disposed.
Your lordship, the Jahangir Alam is the driver, your lordship.
Whatever, I have given the liberty. Yes, next. 36.
And your lordship, one of the witnesses, that is independent witness, has been examined and not supported the prosecution case, your lordship.
That's right. You can renew the bail plea after material witnesses are examined, and trial court
It
is
may be
directed to do well to see that the material witnesses are examined preferentially over the formal witness. Yes.
My lord, this is from Jagashampur. It is a case of under section 21B of NDPS Act. Custody since 1/2/24, more than 7 months, and seizure articles on 23 gram, much less than commercial quantity.
What is the recovery?
123 gram of
123 gram heroin.
100?
23 gram heroin.
Heroin.
My lord, custody only 1 to 24. And my lord, he has 3 numbers of antecedent. One is under the NDPS Act.
So what to do?
My lord,
You have antecedent, you can't get it.
my lord, only one antecedent, so small quantity.
That only one is enough for 37. Even if I'll grant you bail, I'll have that condition. I'll put that condition.
Any condition, any condition.
Oh, the same condition. Subject to verification of then
Antecedent.
you can't come out, but you will get a bail order.
And
You want
only,
that?
only one.
I'll grant bail.
Who's here?
That condition. What if he will not come out?
Now,
He can say that I got the bail then.
and my lord, the trial judge is not there, so there is no question about the time going trial. Only 8 months of custody.
1 minute. Petition is accused in so allegation is a petition so. It is alleged that the what is the quantity?
My lord, 100 to 23 gram.
123 gram of brown sugar.
Heroin. Yes, ma'am.
Heroin has been recovered from the position of the petitioner. Petitioner is in custody since 1/2/2024. Regarding head to the quantity of contraband seized and the period of custody, I'm inclined to admit the petitioner of bail subject to consent and subject to verification of the LTC. You have done your job, and thereafter what happens, that is his fate. Yes.
7. Legal lordship.
The condition is to keep it.
Legal lordship. The petitioner,
Subject to verification of similar incidents. Yes.
the petitioner is a young lady of
Yes.
age about 25 years. My lord, he is in custody since 2011-2023. My lord.
2011-23.
My lord.
23.
Okay.
And tax sheet submitted on this one 302-120B 201/34 IPC. And the
What are the allegations?
allegation, my lord, there is no eyewitness to the occurrence, my lord.
What is the allegation?
Allegation, my lord.
That can't be allegation that there is no
My lord, I am
eyewitness.
submitting, my lord. The petitioner and the deceased, they are in relations, my lord.
Petitioner and the deceased.
My lord.
Okay.
This fact was known to her husband, my lord, by the villagers, my lord. The husband and the wife, there was a quarrel, my lord. They are settled, and they are a plan to
Both the
kill
husband and
the petitioner.
Killed the paramour of the
Yes.
petitioner.
My lord, thereafter, my lord, they check out a plan. The pigeon petitioner or her husband, my lord, in order to eliminate him, my lord. This petitioner, my lord, telephoned the deceased to come in his house, my lord, that side of the house, my lord. There, my lord, they are taking meal, my lord, jalebi khawtini. At that time, her husband was inside a bush, my lord, came out and assaulted by means of a iron rod on his head, my lord. And there are stone also. He died. So, but the present petition is concerned, their confession, my lord, the husband confessed that he was, this petition was called the deceased to the place.
On the confessional statement of the husband of the present petitioner, that husband of the present petitioner, she was impleaded. And those persons who were named in the affair, they were discharged because they were the family members. One day, my lord, what happened when the deceased was taking food? At that time, a phone call was came to. He told his wife that I am going to. He's a labor, my lord. That the deceased that the going to deliver some goods, my lord. And at that, but without going to that place, he has gone to that present petitioner's house, and they have a plan, my lord. They have then after the plan to kill, my lord.
In any case, this lady was in relationship with the deceased.
Yes, my lord.
And the husband is killed. That's the story.
Husband and wife,
whether
they
he participated in the conspiracy or not, that's
yes, my lord. They have planned.
What evidence you have to that effect?
My lord,
Except the confessional statement of the main.
My lord, only that material, my lord, leading to discovery that iron rod was seized from the present petitioner husband, and from the present petitioner the mobile phone of the deceased and his.
They were in relationship. Everything you will get it.
Now that mobile number and a SIM, my lord, broken SIM. It was
very weak. Very weak.
That is quick, but my lord, no one has seen. There is also last scene theory is not there, and
I tell you, the husband might have killed him And since this lady was involved with that, she might have taken the name of the wife also.
First the husband was apprehended and he stated that both of us.
I know. Petitioner is accused and so on and so on. Allegation against the petitioner is also. The evidence form part of the charge sheet reveals that the petitioner was in fact in relationship with the deceased, which came to light subsequently, and the husband alleged to have patched up with the petitioner and has a conspiracy to eliminate the deceased. Accordingly, it is alleged that the petitioner invited the deceased to her house while they were having meal. While they were having meal, the principal accused, who is husband of the petitioner, assaulted, came inside the house and assaulted the deceased in a iron rod. And the deceased succumbed to the said injury. Subsequently, the principal accused, namely the husband of the petitioner, had made a confessional statement implicating the present petitioner. And recovery is also affected on the basis of the said confessional statement. Recovery of weapon of offense has also been affected on the basis of state confessional statement. Except and apart from the confessional statement of the principal accused, there is no other material which is coming forth against the present petitioner, which is form part of the charge sheet. The petitioner is in custody since 2023. In view of the period of custody, nature of accusation against the petitioner, I am inclined to enlarge the petitioner on bail.
My lord, was a session of the matter. My lord, in the meeting, session.
Yes. 38. Yes, sir, 38. Last time also none appeared.
Is it
Let's see.
case of the year 2000 and 448, 294, 34 only offense.
448?
294 and 34. But 4 times NBW was issued. Subsequently, he was arrested and released. My lord, that for that reason the trial was stalled. My lord. If he will be released, your lordship may put some condition that and each day of the posting will be.
To be released,
My lord,
not
see,
coming
that's-
for thought. Last time also none appeared.
YouTube sir trial sir जी.
Huh?
YouTube पे trial sir जी.
So simply urgent कर दियो, automatically.
Order trial prisoner sir जी.
November कर दियो बस. None appears in the last date of hearing also none appeared in the interest of justice. Urgent.
39.
But you, Mr. Ragada, why should I keep it pending? Because it is burden on the court. I'll simply say, I'll not interfere at this stage.
Trial not concluded.
Right. On the, which was that item?
38.
38 item. On the last date of hearing when the matter was none appeared for the when on 25/4/2024, none appeared for the petitioner. Even today, none appears for the petitioner. Mr. Ragada, Land Council for the state submits that this is a case pertaining to year 2000. The petitioner was absconding. Subsequently, he was arrested after repeated NVW. He could not be apprehended. Eventually, he was arrested on
6/1/23.
6/1/23. The trial is proceeding at an expected pace. Therefore, I am not inclined to enlarge the petitioner on bail at this stage. However, liberty is granted to the petitioner to renew the bail plea before the trial court, and the trial court will decide the bail plea on the basis of material available. Yes.
Sorry, your lordship. 39. 39 also trial over got acquitted from the charge.
Oh, thank you.
But
But this is this, I'll tell you, this is not happy. This is a very sorry state of affairs. Somebody is acquitted and we are not able to decide the bail plea. And who will give compensate to this man who remained in the jail for such a long time? The system is not going to give it. But his-
bail ଅଧିକା ଆସୁ today 3,700
I'm trying for that.
ଆମର ରହିଲାଣି 6,500 3,700 ଆସିଛି ପାଖାପାଖି
50 ଟା ଭାଇ, beyond that career ବହୁତ difficult. Back office work is the
482 ବେଶୀ ରହିଯାଉଛି
back office work is also so huge. Very difficult.
Sir, urgent matters, not case matters. Case matters.
There are urgent matters. What to do? We are trying to accommodate as much as possible. Yes.
Delhi 3,000 some ଆମର ମୁଣ୍ଡ 600 6,500 ପର୍ଯ୍ୟନ୍ତ ଆମକୁ ଯିବାକୁ ପଡିବ 3,700 ଚାଇଛି 6,500 ପର୍ଯ୍ୟନ୍ତ ଆମକୁ ଯିବାକୁ
No, no. We have about 600.
ହଁ 6
We have both. There are many matters disposed of. Yes.
40.
Yes, sir.
Initially, the FIR was lodged under section 3.
Custody. Tell me the custody.
Custody, my lord. Custody since 12/11/2023, my lord. My lord, in this case,
302.
no, not
Not with him.
no, 395. In this case, your lordship,
Let him call for this.
well, your lordship has granted bail to one of the court.
But what are the whether rules are same or whatever?
Rules are same, but the present petitioner has no criminal antecedent. The person whom your lordship has granted bail, he has 2 criminal antecedents.
But he might have committed a mistake. Why are you insisting it to be the same thing once again?
Again. So I'm on same footing, my lord. I have no criminal antecedent, and also
What are the allegations? Is there any difference between the allegation between this
supplied
Babu Jana and others? And what is it?
FIR is against an unknown person, and no PI parade has been conducted in the.
Just check it up. I'll put it next week. Next week.
Mr.
Just check
Mitchell,
it up.
Chairman, he is conducting the earlier case, my lord.
Yes. Check it up.
He is conducting the earlier case. I will check.
Check it up next week.
41. Next week. Next week.
Next week. 41. Yes, sir.
Well,
Case there is there.
Yes, sir.
this is a case where, my lords, the petitioner says that she knew 2 persons. She was sitting in a tea stall and these 2 persons come up to her and say, let's go and have a cold drink. And thereafter she is taken and then there is a gang rape, according to her. They are not named in the FIR. They say she says that I know them, but she doesn't name them in the FIR. Be it as it may, my lords, the FIR is unknown. The police says from reliable sources we came to learn. These people, my lords, in the charge sheet they say received information from reliable source that one gas cutter mechanic, namely Chandan Kumar Sharma, and helper, namely Rohan Lohar of
164. Read 164. 164.
160.
164 statement of the
Yes,
victim.
164. Yes.
Read it.
And another thing, my lord, your lordships may, the medical report, she has been examined the next day. It categorically states that there is no sign of forced sexual intercourse. She is a woman.
No, they have confessed, lordship. Both the petitioner Chandan and they confessed.
Confession is not there. You custody since?
Lordship, that is
31.
চা দোকান করছে মোর স্বামী মরে যাইছে
31
Bode 2011-23.
Sorry, I didn't get you.
21. One is 2011-23. Petitioner number 2 is in from 21/11/23. Custody.
11/23. Okay. Yes. 164.
ମୁଁ ଚା ଦୋକାନ କରିଛି ମୋ ସ୍ୱାମୀ ମରିଯାଇଛି ମୋ ଘର ଭାଙ୍ଗି ଯାଇଛି ବୋଲି ମୁଁ କିଛି
I'm only relying on the medical.
Falsity of allegation elucidated from the medical evidence.
Medical.
Which indicates that there is no possible sexual intercourse on the prosecutor.
Man. Like. 42. Well, it's a free copy may be given to him so that he can communicate. Otherwise, they will say that this was never communicated.
And this copy will go to trial court automatically.
Mal. Sometimes it's not going well. That is the problem.
Automatically. And I indicate that the Mr. Board, the state undertakes that the petitioners shall not seek adjournment before the trial court on any pretext, and mark the pace of the trial.
Okay. Okay.
Below, before petitioner before lordship is a widow, and she was working as a Asa Karmi. She is inside custody since 30th of March 2024.
March?
And the yes, 2024. Yes. The case while the investigation in one UD case was continuing, during course of inquiry of that UD case, it came to light that the deceased victim, she was with a illicit relationship with another boy, and they had got
376.3 is there. Where is
376.3 is there.
Notice issued. Notice issued. Notice is required.
Notice is.
You have impleted. Prosecutor impleted.
Yes, already.
Mr. Mahapatra and counsel for the petitioner submits that seeks leave of this court to implead the informant and victim in the present case.
The informant victim is not the informant because the police is the informant here.
Whatever. Police is there, na? And leave is granted to implead, issue notice to the impleaded opposite party, written will up to 2 years. Yes. Next.
43.
I let me fix a short date.
No, he will give. Yes.
43 may be
Yes.
The FIR alleged offense 372L, 294, IPC, their lordship. Procedural lordship, petition procedural lordship 83/2024.
Sorry?
18/3/2024. Charge sheet is submitted, lordship.
Date, clearly tell me the date.
Lordship.
Date.
Date of arrest 18/3/24.
Okay. Okay.
Victim is a major lady, 35 years age, lordship. The alleged offense on 372L and 294/506 officer. In the meantime, lordship, the matter settled between both the parties, lordship. Informant also appeared in.
My lord, I am appearing for the informant, my lord.
What do you say?
The matter has been settled between the parties, my lord.
Have you filed Wakalatnama?
Yes, my lord. Wakalatnama along with the affidavit.
Where is that affidavit?
Flag A, yes, lordship.
Flag A, my lord.
Flag A. Yes.
376.
376, the major girl. She is giving a what? Now he has given consent. Not that time. By way of affidavit. Petitioner is the accused in so-and-so, allegation is petition so-and-so. After investigation, charge sheet has been filed?
Yes, the charge sheet is filed.
Filed on?
10/5/24, lordship. 10/5/2024.
For offences under section?
372.
376(2)N.
L2L 294/506 IPC.
When the matter stood thus, the petitioner submits that he has
that affidavit may be verified, madam. We'll take instruction on affidavit.
Where is that affidavit? Let us see.
Before oath commission.
Oath commission.
Oath commission. Before oath commission.
Satyavati
Satyavati Samantaray.
Here, my lord, Satyavati Samantaray.
Okay, I'll just I'll do that.
Samantaray.
Father
filed the affidavit, my lord.
Informant is a father. Informant is a father.
Satyavati. Who is the
Informant is a father.
Father of the victim.
Hey, who is Satyavati?
Satyavati. Father.
Satyavadi, na
Satyavadi. Satyavadi.
When victim not from my lord, how
You have not settled the victim. Okay, you paid to father then.
Yes, Lord.
You pay to the victim also, and bring it.
Unless until my father might be
Okay,
compromised.
settle the issue. Settle the issue. The petitioners have placed on record an affidavit of the informant, who is the father of the victim, so and so appears for the informant. The affidavit indicates that in the affidavit, the informant states that he has no objection if the petitioner is released on bail. Learned, who is appearing? Then counsel for the state submits that the authenticity of the affidavit needs to be verified, and the affidavit, no credence should be attached to the affidavit, because the affidavit is filed by the father of victim, father of the victim being a major.
35
victim is, what is this?
35 years.
35 years.
Yes, Lord.
Why can't you bring her affidavit? She's not why the father is giving affidavit? You can get from her. Is the victim 31 years?
Without knowledge of the victim, father
Might be, right.
My lord, last occasion, both father and the victim both are present in the court.
It's all right. Wonderful. Have you filed Wakalatnama for victim also?
Sorry, man.
Have you filed the Wakalatnama?
No, my lord, I am appearing for only for the informant.
Okay. Being a measure of 31 years has not filed an affidavit. At this stage, the counsel for the petitioner seeks an adjournment. I am just simply adjourning, recorded everything.
Yes,
bring an affidavit of the or bring her. I'll just record her statement. I'll enlarge you on it. Bring that girl.
Obliged.
44.
Yes, sir.
Petitioners are in custody since 20th October 23.
20th October?
20/10/2023.
Okay.
Suspected offense under
302.
302, 201, 35.
CD?
Yes, CD, everything is there.
In the meantime,
PM report could not possible due to they burned them. Funeral made after the death. The allegation is there, and PM could not be possible. Only police personnel only got some access from the
I didn't get
it. As per the allegation, they forcibly mentally and torture and forcibly they with beat. That is not the knowledge of the anyone. And funeral made within the night, and they inform they inform the
dead body also.
informed on the morning when they went there. At the time, everything has been completed.
And the present petitioners are the father and mother of the principal accused. And in the meantime, trial already commenced, and 14 of the witnesses already examined, including the parents of the deceased.
Yes.
And none of the witnesses support
when
the prosecution.
the last witness was examined?
Last. August. 22nd August.
22nd August 2024.
Yes.
22nd August of this year. Yes, tell me.
And the fact of the case is, the prosecution fact is,
Don't tell me the fact, tell me the allegations. And what are the, what these witnesses are saying.
No, I have only deposition of 8 witnesses.
8 witnesses.
8 witnesses present.
Yes.
Right. Petition is agreed by the order dated 3/4/2024, whereby his bail plea has been rejected. Subsequent thereto, 8 witnesses have been examined by the month of
And
August.
14 already examined, but 8 available with me.
Subsequently, material witnesses have already been examined by August 2024. By August 2024. Since subsequent to the rejection of the bail application, the material witnesses are examined. The petitioner is given liberty to renew the bail plea before the trial court, and the trial court shall decide the bail plea afresh, taking into consideration the material which has come on record by now.
And one thing is there. One thing, petition number 2 is a lady and is suffering very cardiac problem when he is in custody. Last month, 5 days already admitted in the SCB.
The petitioner also submits that the petitioner number 2 is a lady and suffering from serious ailment. Liberty is granted to the petitioner to move appropriate application seeking interim bail on the ground of health ground. If such application is moved, the same shall be considered after verification for the authenticity of the plea raised by the petitioner. Yes.
Lordship admits, my lord, just one submission, my lords. My lord, today is a very auspicious day of Guru Devis, my lords. I also crave a lordship permission to congratulate lordship, my lord. All my friends join with me, my lords. After lordship joining in this particular institution is gather momentum and give the much needed impetus disposal of many old matters. I congratulate again, my lords, for completion, successful completion of 1 year.
Thank you very much. Thank you. Yes, yes, madam.
86. Second time. I allow the.
Your brother might have done it. What to do?
Without knowledge, without notice, without consent of the petitioner.
With the for same.
That may be sorted.
Oh no. Date is see, Mr. Maharana has some personal problem, some medical issues there in the family. Okay, so therefore he has made a request that wherever he is appearing, please accommodate. So that is how the matters will go beyond 18th of this month, because some medical urgency is there in the family. 18th of this month, he is busy. And very
Carrying his sister, my lords, for medical cancer.
Seriously ill. So that is the reason I am accommodating, nothing else.
Item 53, my lord. Item 53, not press, my lord.
Not press 53.
Yes, for the first judicial anniversary, lords. We all congratulate your lordship.
Judicial anniversary. You have coined the right word to fit the occasion. Thank you very much. Thank you.
Congratulations.
Not
Interfering also. When I appeared on the when the matter was taken up on 25/4/2024, it was simply urgent to 20/5/2024. None appeared on that day. And on the second call, today nobody appears for the petition. Hence, this dismiss. Yes.
45.
May I please, my lord, pray for Arjun because my senior sir, pray for Arjun, sir.
You want an adjournment?
Yes, sir.
Okay. With request, adjourn.
46.
Yes, sir.
May it your lords. My lord's petitioner is a lady and he is in custody since 11/2/2024, my lords.
11 to 24.
2024.
Okay.
Charge sheet submitted 304 IPC, my lords. Culpable homicide not amounting to murder. And as per the investigation revealed from the charge sheet, my lords, I am placing that up. I will pass it over, my lords. I am reading out from the charge sheet, my lords. The fact of the case
You
on.
have CD with you?
Yes, my lords. On 10/2/2024, at morning, the deceased Rajendra Munda had been to the house of one Vishnu Munda for attending funeral ceremony, consuming mahua liquor. At about 2 p.m., he returned to his house and again drinks mahua liquor and went to the house of Vishnu Munda. At 12 midnight, the deceased returned back to his house in drunken state. Thereafter, deceased Rajendra Munda along with accused Jema Munda and others went to the house of one Suresh Munda for settlement of a quarrel of that family. In the meantime, the deceased Rajendra Munda had slept in the house of Suresh Munda for being in a inebriate situation.
Inebriated.
Drunken state, my lord. So the accused Jema Munda, Ronde Munda, and Monica Munda returned to their respective house. At 1 a.m. in the night, the deceased returned back to his house in drunken state and all of a sudden quarreled with the wife deceased, Jama Munda, and assaulted her by means of wooden stick without any reason. To save herself, the accused snatched the said weapon of offense, that is a wooden stick, from the hand of the deceased and assaulted him by means of said weapon of offense, wooden stick, on his backside with no ill intention.
Okay.
The
What is this? I think he's entitled.
Wife and
he came in an inebriated condition and started beating. To save herself, snatched the wooden this thing.
wooden stick, he backside of the head.
Gave a
Head PM report also head injury there.
Head injury, gave a blow, died. Petitioner is accused. So allegation against the petitioner. The investigation revealed that on the date of incident, the deceased, who was the husband of the present petitioner, came in an inebriated state and started physically assaulting the petitioner. The petitioner, in order to save herself, snatched the weapon of offense, and gave a head blow to the deceased, to which the deceased succumbed. This is a case of single blow. And the petitioner, admittedly, the deceased was completely, this disease was in a drunken condition and physically attacked his wife, namely the petitioner. Save the life, the petitioner has snatched the weapon of offense and gave a blow in turn. Petitioner is in custody since 11/2/2024. He is a lady of 35 years old. There are children.
Children, I don't know.
And regarding head to the aforementioned, is entitled to bail and grant. Yes.
47.
Yes.
May I please, Your Lordship? This petition was filed for two petitioner earlier. But today I want to, may I permitted to not press for one petitioner and allowed to move for another petitioner.
Sorry,
Because
you don't want to press the petition?
one Niranjana Gowda, as because he was released on default bail.
Default bail.
Yes, my lord.
Okay. And what about Soumya
May I permitted to move?
Yes, yes, tell me.
The present petitioner, namely Soumya Ranjan, is in custody since 22 January 2024.
January 24.
22 January 2024.
Yes.
And the allegation against this present petitioner is under section 307, 294, 149 of IPC. And your lordship kindly perused the medical report of MKCG and in 31, page number 31, the opinion of MKCG Medical Hospital that the injured sustained the injury due to fall down on his head.
30, 39.
31.
31, let's.
31 is the medical report.
Which page?
31 page.
31, okay. Relevant page?
First, the MKCG, the opinion of MKCG Medical College that the injury sustained by the injured is due to downfall of on his head.
Which part you are reading, madam? You please tell me which part.
First two line. 31
Page, page 31.
Yes, my lord.
At the top.
At the top.
Injury due to
downfall of on his head. Injury due to fall down of on his head, on land on his head.
fall, due to fall.
Yes.
Of what is written here?
Around 10 cm over the left side of the head, our parietal area, 8 cm to post of the head.
Yes. Then what do you want?
And kindly peruse the discharge report, page number 39. The IO has filed his opinion at 39 page in last line that the present injured Anil Panda is in his house and taking medical daily as per the advice on dated 22/2/24. He was discharged from hospital on 22 February 2024.
Yes.
And he is in a good condition. And
what are the injuries caused?
Injury due to tussle between two parties, and during tussle the injured fall down on his head and sustain injury. They are all co-villager, and due to the ward actions of between them.
You what are the allegations against this number 2? Number 2.
So there is no there.
Soumya Ranjan.
CD has not come out from this. Here it is there that lordship page 23 order sheet lordship. That the Santosh Kumar Gowda, it is son-in-law, Dharambu Gowda, were giving threats to kill injured Anil Kumar Parida while standing in the front of his house. They are holding crowbar. When Anil Parida was returning after the finishing the Shraddha of his father, accused Mahadev Gowda, his 3 sons and his son-in-law assaulted him on his head by means of the crowbars, for which Anil fell down.
Who is he? This man.
This is Lordship Niranjan Gowda.
And one of the co-accused is released on granted by the bail from lower court.
Who?
Lambadar Gowda is released on bail.
Where is that? Where is that order?
In session court. It has not filed because after filing of this record, the co-accused is released by the.
You file it and put it next week. Next week, counsel for the petitioner submits that insofar as the petitioner number 1 is concerned, she doesn't want to press this petition as the petitioner has already been released under section 167(2) of CRPC. In so far as the other co-accused person, what is his name?
Lambadar Gowda.
Damodar Gowda is
Lambadar Gowda.
he has already been
Lambadar Gowda.
He wants to place on record the order of the court enlarging Damodar.
Lambadar Gowda, may lordship correct the name? The Lambadar Gowda is released on bail.
Please the matter next week. Yes.
May I please, your lordship, not Damodar, it is Lambadar.
Lambadar,
not Damodar.
Lambadar, yes.
48. My lord.
The petitioner's custody since 1/3/2024 and of alleged offense under 20B2C of NDS Act.
40 kg lots.
40, there are two bags actually. 40 kg. 40 kg. Yes. Already charge sheet submitted on 28/2024. 28? 28/8. 28/8/2024. Yes. 40 kg. 40 kg. No antecedent. No antecedent. Oh, but with the same condition, subject to verification of antecedent, 40 kg. He is in custody since 1/3/2024. Okay. Charge sheet filed on 28/8/2024. Okay. Yes. 49. Obliged.
Petition is in custody since 11/3/2024.
Sorry?
11/3/2024.
11/3/24.
For the alleged commission of offense under section 302-201.
CD is not.
CD called for CD. Yes. Next. 3 weeks. Huh? 3-4 weeks.
May it please, my lord.
Yes.
The petitioner is in custody since 1st of October 2023 for alleged offences under section 302 IPC, my lord.
Yes. CD is there?
Yes, yes, 51 million.
My lordship, the prosecution allegation is that the petitioner assaulted the deceased by way of a tangia and a lathi, thereby causing the death of the deceased, my lord. May I humbly bring to my lordship's notice the FIR, which is at page 10 of
Yes.
my lordship. The informant is one Malkunda Naik. He alleges in the FIR that on 1/10/2023 at about 5 a.m., he saw Rabesh Naik, Sahadev Naik, who is the petitioner before my lordship, one Nakula Naik and Montu Naik, 4 persons, my lord. They assaulted his cousin by way of tangia and lathi, because of which he succumbed. The police, after the registration of the FIR, took up investigation. Allegedly, there was confession by the petitioner in police custody, thereby leading to discovery of the weapon of assault, and some alleged independent eyewitnesses to the occurrence, namely one Bijoy Naik and one Amrut Naik. The other 3 accused were exonerated on what materials that has not been revealed in the charge sheet. Charge sheet has been submitted against the petitioner solely under section 302 on 25/1/2024. May I humbly place on before my lordships the 164 statements of the independent witnesses proposed to be arraigned by the
Amrut and Vijay.
Yes, my lordship, it is also pertinent to mention here that the informant, though he claims to be the ocular witness to the incident, has not revealed about the presence of any other persons anywhere near the spot, my lord.
Informant is not eyewitness. Here, there
The
are
FIR reveals same, my lord.
There are 5 eyewitnesses across. They have categorically stated that present petitioner assault on the head of the deceased by axe thereafter cut neck by a Kati Millard. Both are recovered from his under section leading to discovery Millard. Both are recovered from his house.
Wait till material witness.
My lordship, may I humbly submit, my lord. My lordship, only may I ask the learned counsel for the state to submit the 161 statements, because none of the witnesses have named the other witnesses,
But
and also one of the
two witnesses have already been examined.
My lordship, another mitigating circumstance in my favor is, may I humbly place para 7 of my bail application, my lord. Unfortunately, right after, my lordship, there was previous enmity between the families of the petitioner and the deceased. That is admitted, my lord. Right after the incident, based on suspicion, he has been implicated. On 10th, my lord, my lordship, may I complete my submission? May I humbly submit, my lord? Bulldozer ନେଇକି ତା ଘରଟାକୁ ପୁରା ମାଟିରେ ମିଶେଇ ଦେଇଛନ୍ତି. The family of the deceased,
That might be the reason of motive.
My lordship, FIR ପାଇଁ ତା family ଚେଷ୍ଟା କଲେ ହେଲାଣି, ହେଇପାରିଲାନି, ସେ superintendent କୁ petition ଲେଖିଲା. My lordship, these are motives. My lordship has always held that it is a twin-edged sword, my lord. That will.
I am not deciding your.
My lordship,
just
charge be frame hai parne. Though charge sheet has been submitted since January.
That I'll make sure that things will start moving. Right. petitioner is accused in so and so. The petitioner is in custody since 1/10/2023. There are how many witnesses?
Five eyewitnesses.
There are allegedly there are 5 eyewitnesses to the occurrence, and out of them, 2 witnesses, namely Vijay Kumar and Amrut, has been the statement of 2 witnesses, namely Vijay and Amrut, were recorded under section 164 PRPC. And consequently, the petitioner submits that although the charges have been framed, but the trial has not.
Your Lordship, charge has not been framed. So.
Consequently, the petitioner submits that even charges has not yet been framed in this matter. The petitioner is the sole accused.
I'm
Petitioner
sorry.
is the sole accused.
Yes, my lord. As per the charge sheet, he is the sole accused.
Who is in custody since 1/10/2023. In view thereof, I am at this stage I am not inclined to enlarge the petitioner on bail. However, liberty granted to the petitioner to renew his bail plea after the eyewitnesses are examined. The trial court is directed to do well to see that all the eyewitnesses are examined preferentially over the formal witnesses, and after the eyewitnesses are examined, the petitioner may move the application for bail. If for any reason the eyewitnesses could not be examined within a period of 6 months, even then the petitioner continue his.
May I humbly pray, my lord, 4 months because sir, dita sano chua achanti. ଘର ଦ୍ୱାର ସବୁ ଭାଙ୍ଗି ଗଲାଣି my lord. They have become destitute, my lord. I humbly pray, my lord, 4 months.
Whichever is earlier.
My lordship, 4 months खाली कर दें तो
Next.
my lordship 6 months.
It is easy for you to tell 2 months.
I understand. I bow down.
How the pressure charge is not frame. I am giving you 6 months. And it is a big pressure on the trial court, you know.
That I understand. I bow down, my lord.
But it's very easy to tell 1 month, 2 months. I'll tell. But what kind of pressure I am creating?
But because of the mitigating factor, my lord, he is a victim of bulldozer justice. That is the only reason I was.
That's the best justice now.
I was only seeking my lordship's indulgence about.
Next.
Oblige.
52. Yes.
Please, your lordship.
Yes.
Here I am in custody since 29th of January
29th January.
My lords.
24.
Charge sheet has been filed on section 376(2) and 292A of the IPC. 6 of the.
On behalf of Mr. Naik, I am the informant. On behalf of Mr. Naik, kindly praying for any day next week. Appearing for the informant.
Let's see whether I'm giving bail or not. If I'm giving bail, then I will return it. let me just understand.
Mine.
I note your request. Can it be done then next week? Unnecessary wait. Next week. Okay. Next week. On request.
City available.
City available
Yes.
next week.
54. Much replacement.
Adjournment on behalf of my learning senior.
My name may be.
Mr. Ponda's name is reflected in the court. Yes. Yes. 55. Who is appearing? None appears for the petitioner in the interest of justice. Judgment. 6.
May I please, your lordship?
Yes, sir.
The petitioner in custody since 5th February 2024.
Yes.
And charge sheet has been filed on 30th May 2024 under section 306 of Indian Penal Code. 306.
306.
Yes, please. Allegation is just like this, plus.
Husband?
No. It is the deceased has taken some loan from the accused for her daughter's marriage, and he could not repay.
Deceased had taken loan.
Because he insisted to pay him back the money, whatever he has taken. So that is the reason he took poison and ultimately died. So in that way,
suicide note is there.
Yes, that is the reason why this is abetment to suicide.
What is
charge sheet copy not with me, my lord? CD available, charge sheet copy not with me.
Yeah, charge sheet copy no.
Yeah.
That one.
He has taken loan, the deceased,
No, what
and the
hap-
petitioner asked for money, he
No,
committed suicide.
that's not exactly case. What happened, my lord? Petitioner along with another person, my lord, came to the house of the deceased, my lord, forcibly took him to somewhere, my lord. Thereafter, house family member of the deceased searched him, didn't find, my lord. Then same day, 11 PM, my lord, they found the dead body found in a cultivated land, my lord. Present, my lord, petitioner is a money lender, my lord, as well as he has a pesticide seller, selling the pesticides, my lord. And postmortem report saying, my lord, ingestion of irritant poisons substance, my lord. So, my lord, person, my lord, forcibly carried out by the present petitioner in a motorcycle, my lord. Thereafter,
Why have you not filed charge sheet under 302?
my lord, charge sheet copy just now received.
306, why 306?
ସେଇଟା ଆଜ୍ଞା ପଢିନି କାହିଁକି?
Whatever you are narrating, is the case of 302.
Yes.
Why have you filed 306 then?
ସେଇଟା ଆଜ୍ଞା ମୁଁ ଚାଷୀ just ଦେଖିଲେ ମୋର tension ଯିବ.
May I permitted to read the statement of the wife of the.
No, let him see the story which he is narrating.
No, that was the story in the FIR.
You kidnapped him.
No,
forcefully you have taken, administered poison, and thereafter the body was found subsequently.
That was the story in the FIR for which it was registered on 302 and 34 of the Indian Penal Code.
What happened?
And ultimately it has been found.
I'm placing winner. Thereafter, sought his father on the same day at about 11 PM, found him in his field in a critical health condition, then shifted to medical for treatment, and later shifted into Burla Medical for better treatment. At Burla Medical, his father died. Accused took his father and administered poison and killed him and threw him in his field. Before some days, his father took fertilizer and pesticide from the accused, present petitioner, my lord, for which he threatened to kill his father. Accused Sunadhar Satua also lent money to the villagers as per interest basis. The accused also selling pesticides in the village without any valid license. I took the charge sheet during course of business, sent the requisition so and so, and the requisitioner equivalent cause of injuries, cause and nature of injury found in the stomach are antemortem nature constituting injection of irritant poisons or substance. Said the Mishra, I think subsequently
306 came there,
found in the stomach. Has consumed poison in the stomach.
See the charge sheet also says it is 302. Basically, call for the CD.
No, CD is there.
Update CD, I'll call.
CD is there. Update I'm serious. Plus, your I'm reading the. I'm
reading.
Let me no problem. I'm reading because that person there be
the charge sheet is read out. According to me,
charge sheet only to know the date when the charge sheet is filed. That's the reason. And he has got the CD. I'm reading the statement of the wife and the brother of the deceased. What the wife stated. ମୁଁ ରୁଦନା ସାହୁ ସୁଆଂଶୁ ମୋର ବୟାନ ଏହିକି ଯେ ଗତ 29 ଜାନୁଆରୀ 2024 ତାରିଖ ଦିନ ସନ୍ଧ୍ୟା ସମୟ ପ୍ରାୟ 6:30 ରୁ 7ଟା PM ସମୟରେ ମୁଁ ଘରେ ବସିଥିଲି। ଏହି ସମୟରେ ଆମ ଗାଁର ସୁନାଧର ସାଥୁଆ ଓ ଶିଶିର ପ୍ରଧାନ ଓ ବାଘ ଏକ ମୋଟରସାଇକେଲ ଆସି ଆମ ଘରେ ପହଞ୍ଚି ମୋର ସ୍ୱାମୀଙ୍କୁ ମୋଟରସାଇକେଲରେ ତାଙ୍କ ଘରକୁ ନେଇ ଯାଇଥିଲେ। ଆମ ଝିଅ ବାହାଘର ବେଳେ ଆମେ କିଛି ଟଙ୍କା ତାଠୁ ଉଧାର ଆଣିଥିଲୁ। ସେଇ ଟଙ୍କାର ସୁଧ ମଧ୍ୟ ତାଙ୍କୁ ଦେଉଥିଲୁ। ସେ ତାଙ୍କ ସମ୍ପୂର୍ଣ୍ଣ ଟଙ୍କା ଫେରାଇବାକୁ ଜିଦ୍ କରି ଓ ହିସାବ କରିବାକୁ ତାକୁ ଡାକି ସାଙ୍ଗରେ ମୋଟରସାଇକେଲ ନେଇ ଯାଇଥିଲେ। କିନ୍ତୁ ମୋର ସ୍ୱାମୀ ଆଉ ଫେରି ନଥିଲେ। ହେଲେ ରାତି ଅଧିକ ମୋର ଦିଅର ବିଭୀଷଣ ପୁଅ ଆଶିଷ ଆମ ପଡୋଶୀ ଲୋକମାନେ ତାଙ୍କୁ ଖୋଜାଖୋଜି କରିବା ବେଳେ ଆମ ଘରଠାରୁ କିଛି ଦୂରରେ ଥିବା ଆମ ବାଇଗଣ ବାଡ଼ି ପାଖରେ ତାଙ୍କୁ ବିଷ ଖାଇ ଗୁରୁତର ଅବସ୍ଥାରେ ପଡ଼ିଥିବାର ପାଇଲୁ। ସେମାନେ ତାଙ୍କୁ ସାଙ୍ଗେ ସାଙ୍ଗେ ମୋଟରସାଇକେଲରେ
for settling the
to ହିସାବ କରିବା ପାଇଁ
dead body was found.
last line I'm reading. ମୋର ସ୍ୱାମୀ ସାଧୁ ସାହୁଙ୍କୁ ସୁନାଧର ସାଥୁଆ ମାନସିକ ନିର୍ଯାତନା ଦେବା ଯୋଗୁଁ ସେ ବିଷ ଖାଇଛନ୍ତି। Then ବିଭୀଷଣ ସାହୁ the brother is also telling the same thing. ମୋର ଭାଇ ସାଧୁ ସାହୁଙ୍କୁ ସୁନାଧର
yes. Next. 57. The police can do anything. Yes.
Maybe.
If there is no case, they'll file 302. When there is a case, they'll file.
No, because in the FIR they have stated ingestion.
And he has taken this disease in the motorcycle. That has come.
That is same.
Dead body was found subsequently, that has come.
Yes.
And thereafter you say that it is conjugal poison because 161 statement.
Because in postmortem report, poison found.
Who has given the poison?
Yes.
And also you are saying that you have a pesticide shop
Miller.
illegally running.
That is also there.
And pesticide is found in his stomach.
Yes, yes.
If he has a pesticide shop, how the disease will take? Unless he has administered it.
No, pesticide he can
These
take
are
from
Yes.
very
Miller.
simple things.
Miller.
And this
There are no external injuries. No external
may
injuries.
not be.
Yeah.
You are running a pesticide shop. You have taken him from his house. That evidence has come.
Plus, only evidence
How,
has
where
come
from? How he has died by poisoning?
by poisoning.
Poison was in your possession.
No, no,
According
but
to them,
that, no, that is not the case. Plus, let him get the case diary. Plus, everything will come up.
It is a case of
Let him get.
302.
It's not a case of 302 plus because rightly 306 plus it has been filed. The final form has been filed under 306 of the Indian Penal Code.
Rightly made to be filed.
Plus, investigations are done by the prosecution.
Rightly made to be filed.
And see pesticide ଦୋକାନଦାର ଥିଲା ବୋଲି 6 ମାସ ଭିତରେ ହେଲାଣି 2 ରୁ 8 ମାସ ହେଲାଣି 6 ମାସ ଆସୁ ଆଜି ଲର୍ଡସିପ yes
57.
You are in from February.
yes lord from 5th February 2024 and ନୂଆ ଖାଇ ଅଛି ବୋଲେ 2 ଦିନ 3 ଦିନ ପରେ ଏ ଲୋକଟା ସେ ପାଗଳ
poison କରୁଛନ୍ତି ଆମେ ନୂଆ ଖାଇବା ଆପଣ
ଦେଇନି ଏଥର ଧାର ଦେଇକି ଜେଲ ରହିବ
ଆପଣ poison ଖିଲଉଛନ୍ତି ନୂଆ ଖାଇ ଚକ୍କର କରୁଛନ୍ତି
ଧାର ଦେଇକି ଜେଲ ରହିବ ଆଜ୍ଞା ଧାର ଦେଇକି ଧାର ସୁଝ ନ ପାଇଲେ
The problem is when you change the side, then your voice changes. That's the whole difference. If you would have been that side by now, the defense counsel would have been in a deep.
ମୁଁ ଏଇଭଳିଆ ଆର୍ଗୁମେଣ୍ଟ କେବେ ବି କରିନଥିଲି 306 ଟା ବାଡି 302 କରିଦେବି ଇଏ ଚାର୍ଜସିଟ୍ ପରେ
Okay. Yes. Yes. Next.
May I believe? Offense under 380 and 34 IPC.
380
and 34 IPC.
Yes.
Offense trial by magistrate, my lord. And custody since 3/4/2024, my lord.
3/4/24.
My lord. In the meantime, charge sheet was submitted on 31/5/2024, my lord.
31/5.
5. Charge sheet was submitted, my lord.
Yes.
And my lord, I also supplied the charge sheet copy. Allegation that 2 unknown person came to the shop and asked to the salesman to show the gold chain. He is salesman, so 12 numbers of gold chain where are in a box. The approximately weight is there something. And interview in the time they kept busy by the salesman and asked to show other ornament. In the same time, one person kept secretly 12 numbers of chain and other accused started the vehicle and they left the place. And on the suspicion
in the jewelry shop.
Jewelry shop. And in the suspicion on 3/4 occurrence was taken place.
Anything recovered?
Yes. What happened, my lord? 2 persons came, my lord. Entered into the
including
him. One thereafter came back and start his motorcycle in the road, my lord. What happened? Present petitioner, my lord, taken away 12 number of gold chain, my lord, and ran away with the motorcycle, my lord. That has been captured in the CCTV, my lord. That apart, my lord, from the exclusive possession of the petitioner, 5 gold chain has been recovered, and so far as criminal antecedent concerned, my lord, is man from Maharashtra, my lord. 8 antecedent in West Bengal, my lord, 2 in Baleshwar, 1 in Maharashtra, my lord.
No, antecedent.
My lord, that is man of Nuapada. Man of Nuapada, it was admitted in the charge sheet. And it was admitted by the charge sheet. They had taken 6 to 7 number of gold chain and 5 was recovered.
You are from Maharashtra.
Yes, Nuapada, my lord. It was reflected in charge sheet rejection copy, my lord.
You have given the address yourself.
In the forwarding report also. I have also annexed that.
You have antecedent throughout India. You are doing all this.
Only.
And other accused has not been recovered, not been arrested till that.
Charge sheet submitted.
Preliminary charge sheet.
Regard being head to the petitioner is accused also. Allegation against the petitioner is also. Counsel for the state submit that the other co-accused persons have not yet been apprehended. They are outstanding. The petitioner is involved in many cases across the country.
Many not.
The country. There are how many cases?
8 in the West Bengal, 1 in Maharashtra, 2 in Balesar.
8 in
West Bengal. 1 in Maharashtra.
1 in Maharashtra, and
2 Balesar.
2 in Orissa.
Yes.
2 in Orissa. Keeping in view the antecedent of the petitioner, I am not inclined to enlarge the. Yes.
58.
My lord, permitted to withdraw.
Yeah, withdraw.
My lord, date, my lord. Item 57.
57 disposal. Yes, 59.
And liberty make after that, no TI period was conducted, only.
See, you are antecedents are serious. Yes. Next. 59.
May I please, Lordship?
Yes, madam.
Pass over the matter.
Pass over today, no pass over. Now 100 matters and second hour pass over. At the request urgent. Okay.
60.
Urgent, but don't give longer date.
On behalf of Mr. Srinivasa,
Yes.
Custody 9/3/2024, my lord. And charge sheet submitted under section 376, 342, and 506.
Medical examination.
Milord,
164.
Milord, I am placing 164, Milord.
Yes. 376.
Am ghar
Custody since you tell me.
9/3/2024.
9/3/2024.
2024.
Okay. Yes.
ପିଟିସନର ଆମ ଘର ପାଖ ପିଲା ସେ ମୋର ତା ମୋ ସହିତ ସିଏ ମୋର କିଛି ଜିନିଷ ସଂଗ୍ରହ କରି ମତେ ବ୍ଲାକମେଲ କରନ୍ତି ଓ ମତେ କୁହନ୍ତି କି ତୋ ସହିତ ଶାରୀରିକ ସମ୍ପର୍କ ରଖିବୁ ନହେଲେ ମୁଁ ତ ବାପା ମାକୁ ପଠେଇ ଦେବି ଏଇ କଥା କହି 2022ରୁ ମୋ ସହିତ ଶାରୀରିକ ସମ୍ପର୍କ ରଖି ଆସୁଛନ୍ତି ଗତ 5/3/24 ରେ ମୁଁ
Call proceeding.
Madam, I record by submission, absolute no case. Absolute not a single case is there.
I grant the bail, don't worry. Less than 100 gram, 100 kg, I am
With
but
much,
CD has to be there.
with much difficulty listed for it.
No, I am giving a date after 1 week. Get the CD.
Yes.
Yeah.
Coming with Asudal.
Yes.
Coming.
He has to get it, otherwise again he'll ask for time. Wait, without CD it's not 37 is there. It is easy to
It is there.
dismiss, but if you want to give bail, and everything should be there.
10/12/2023, I am in custody. And twice it has been listed before son of court, and the prosecution has now not in a position to.
By way of right, you don't.
No, I am not on that. I am not on that. My humble submission.
Your right is violated, tell me. It is a grace.
No, my lord knows.
It is only a grace.
No, yes, it's a grace because it has been listed. No, it's a grace because it's listed.
Grace will be bestowed timely.
No, I know, I accept it, my lord. It's a grace that it has been listed before, my lord, and I am apprehending if some things will not come in a positive manner, something may happen. Next, any date, my lord?
He's giving a date, don't worry, after a week or so. Yes. All proceeding. Yes. 60? 60. Withdraw. Yes. 63.
63.
And leadership mirror. Here in this application, the petitioner mirror seeking mirror condition imposed by the London trial court.
This is not bail, huh? Bail over?
Bail, sorry.
Lifting of condition, my lord.
Which is the condition?
On page 19 mirror, second paragraph.
Second.
Yes, mirror. Let the accused petitioner be released on bail, furnishing cash security worth of rupees 10,000. That to be mirror left out, and then mirror furnish bail bond of rupees 140,000 with 2 solvent security.
What you are agreed by which one?
Mirror say 10,000 ଟଙ୍କା ଦେଇ ପାରିନି ବୋଲି ମୁଁ 6 ମାସ 4 ମାସ
Cash
ଅଧିକ
security.
Yes.
I'll tell you. Right. The petitioner is agreed by the condition imposed by the trial court while enlarging the petitioner on bail wide order dated 27/6/2024. Petitioner is agreed by the condition. Which condition?
Condition number
of
1.
Of cash security of 10,000.
10,000 and another condition I would say.
And
I would mirror one shall be family members of the petitioner, but one shall be relative of the petitioner.
and the family member of the petitioner.
Family members अच्छी मिलर ता रिलेटिव से ले है जो ता मामू
Family members are also relatives.
से family members बापा माँ भाई के ता रिलेटिव
And furnishing of the surety, family surety.
relatives of the petitioner.
Surety is family member. family member is there.
Is there, head a relative.
You want to make it a family member, one of the family members. Although the bail has been granted to him due to the said conditions, the petitioner could not be released. Therefore, he seeks variation of the law regarding head to the submission made at the bar, and the fact that the petitioner could not be released on bail despite the bail has been granted on 27th 6 2024. The bail conditions are bail conditions are varied. The petitioner shall be released on bail by furnishing surety of 10,000 and you are not outside. Sure. This thing, check it up. Barvil. No, out of them, one surety shall be relative. One surety, yes.
May plus one. Cancellation of bail, my lord. Next to page 16, my lord. Ground is they undertake before this under report that after release from the custody within 15 days, he will pay 1 lakh, thereafter the rest amount. Page 17, paragraph 4.
Three out of 384, 1
Yes,
lakh.
my lord.
Yes.
Kichi delani padega.
Who is there?
No, first time notice.
Issue notice.
Date month.
Yes.
65.
Leave of your lordship, my lord.
Yes, sir.
This is before your lordship on the ground that I had given some financial assistance to a gentleman. He didn't repay, and then he and his son gave me 4 instruments. I deposited it and it got bounced. As it is, I took the process of law and filed cases under section 130.
What happened now?
Now the gentleman has come up to the police station through filing one 1cc case, and your lordship would be pleased to see the FIR that he has given, and that is at page.
Have I issued notice?
My lord,
Notices have been issued.
But notice issued, my lord. But the house of the complainant was locked and nobody could able to.
That is long back. That is long back.
Item delivered. Item delivered. That's the report.
Item is delivered. Yes. And apart from that, I would beg with your lordship the comparative mischief this gentleman plays. In the 138 proceedings before the learned trial court.
I have stayed the proceedings.
Yes, the proceeding has been stayed.
Let the stay continue. Let it not come. You proceed in 138 matter.
Yes, that liberty your lordship may.
138 matter I have not.
No, your lordship can, but your lordship stays the proceeding and.
Right. Yes. Despite service for the notice on opposite party number 2, non-APS to oppose the petition. So in the interest of justice, the matter is adjourned. In the meantime, the proceeding before the court below, which court?
That is JMFC Jajpur Road, related to 1cc case number
52 of
2020.
Shall remain stay till further orders.
Your lordship, I beg your lordship pardon, is 32. 32. Yes.
52.
32 of 2020-21.
Now just see page 13.
No, my lord, that case converted to GR case, na? Now GR case FR has already.
You keep proper this thing, otherwise you keep on moving application.
It was Jajpur PS case number 101. PS case is na charge like na. Only FR, my lord.
No, there the police is after me.
My lords,
you give me, I am going to stay your this thing. Which proceeding to be stayed, you give it.
Yes, your lordship may indicate 1cc case number 32 of 2021.
That now converted
first
to
case. And your lordship may also direct that the PS case may be stopped. Your lordship annexer 2 at page 45 of your lordship's brief.
So
that is Jajpur Road Police Station. Number 110, yes, Korai PS case number
101.
101 of
of
2021.
Arising out of 1 CC case number 32 of 2021. Both
Right.
you can clear it.
In the meantime, I will obtain the CD. Can
You CD get it and
Ask them to
put
investigate.
it after no more.
Final
You
report may be-
continue, you continue.
final
for
report
that
may be
date.
submitted.
Your
in this
lordship
case. List of
fixes
cases.
any date subject to your lordship's convenience,
He will
then it
fix
can
it.
be heard.
He'll fix it. Yes, next.
I'm good.
Yes. Yes, sir.
On behalf of Dilip Kumar Mahant, my lord, kindly taken up next week, my lord. He is the
Urgent at 3 case. Yes.
66.
Notice has not yet been served, and the petition is to take fresh step to serve notice on the opposite party. Yes, please.
67.
Let's item number 67, pray for one passable.
Not possible. Not
So-
possible.
So I am appealing to the opposite reports.
Yes.
So maybe direct from a copy, what has happened in this case lots. So the area dues is more than 3 lakh lots. And so only by virtue of this honorable court's order, only so they have paid 20,000 and they have got it tomorrow. So it's going direct some amount to pay to that.
No, I don't know. I have to hear them. So supply the copy.
Yes, your lordship.
Land
the
counsel
course
for the
of-
petitioner undertakes to supply a copy of the petition to the land counsel for the opposite party release the matter.
So let's do next week. Yes, date will be fixed because
Let's
Date
say
will be fixed. Don't say that date will be fixed. Yes.
Let's say interim order to continue.
so that is there because by virtue of the interim order, so they are taking that plea also and also having a small
That
child.
is the reason I don't give entry orders.
They are-
These methods
Nice,
are
so
employed.
that-
Yes, next.
Of legislature.
Lordship permits, my lords, I may pardon, my lords. Item 103, my lord, lordship cause list, my lords. 103 has been posted today for to taken at 3 p.m. my lords. I'm bringing it to lordship notice. But out of the 3 cases, my lord, one.
How many matters have taken? Fresh गुड़ाक सरजाऊ run through the list.
Again, sorry, Judge.
What will be the defectors are there, madam?
1 minute.
Yes.
68.
My lord, my lord. This is a matrimonial case, but wife doesn't want to proceed this case.
Sorry?
Notice हो
अच्छा,
proceed करिए चाहने वो
issue अच्छा
Case proceed करेंगे?
No.
Order कर दे?
नहीं
Notice
on the
was
petitioner पाई ना
Hmm.
and
wife
respondent
doesn't
पाई किए
wife
किसी नहीं
no.
this petitioner is
Notice
seeking quashing up for the entire quashing up for the order dated 4/1/2021 passed by SDJ and bracket S Cutter in Mahila PH case number 89 of 2020. This dispute is arising out of a matrimonial dispute. Land counsel for the petition submits that the parties are likely to settle the dispute.
No.
Issue notice to opposite party number 2.
490 case.
Denkanad, you are from Denkanad.
My lord,
Cuttack.
my lord, my lord.
Girl is at Cuttack. Okay. In the meantime, the parties are relegated to High Court Mediation Center for exploring possibility of mediation. Also, order करूँगा. Awaiting mediation report. Yes. I am sending you to mediation also.
My lord.
If mediation report comes, we are passing. Okay.
Okay.
69.
May I please? The petitioner seeking to quash the entire proceeding in this case, your lordship. The petitioners are in-laws of the informant. The
No,
sister
notice
in-
issued earlier, my lord.
Hmm?
Notice issued, my lord.
Yes.
Neither AD nor the unserved, my lord. That may be awaiting the.
Police has sought the notice.
Awaiting the but same. my lord.
Notice was issued to
The last occasion also, your lordship, police sought the.
number 2 by order
Yeah,
dated
correct, correct,
4/2024.
ଆଉ ଗୋଟେ ଡେଟ୍ ଗାଈ ସେ ଆସିବ
Postal receipt and AD has not yet been distributed. Therefore, the State Council is directed to serve opposite party number 2 through the IO of the president.
IO already served the copy, his last thing is there.
Already there.
IO also served the copy to the copy
Wait.
number 2, your
It's
lordship.
the last order, awaiting
Sir,
the
copy notice on
service.
that.
Is the matter. Yes.
70.
May I please, your lordship. My lord, we are taking fresh notice regarding the same and we have filed the requisite also today.
Service occupation. The learned counsel for the petitioners.
My lord, may I be allowed to
Press steps for serving.
utilize the unutilized copies also?
By utilizing and utilizing the copy, advance copy already filed. Let me take the steps. Okay. Yes.
71.
Made Lordships. Lordships, here Lordships 311 petition has been rejected. Lordship, last occasion, in fact, I was in prayer, Lordships, I have prayed for recall of witness 6, 12, 14, 15, 16, 17, 18, 19. But I will confine to Lordship 17, 18, 19 only.
Where is the application?
Application Lordships for recall of the.
Where is that application?
Your Lordships, I have not annexed, but I have obtained the certificate copy.
No, I don't need certificate copy, but show me the application, show me nothing. You have not filed anything except
Yes,
order of
Lordships.
rejection.
Your Lordship, last occasion was suggested to give the proposed questions.
You have to place it on record, sir. Neither the 311 application is there, nor the evidence is only that rejection order.
Yes, Lordship.
How will I decide it?
That's why Lordship suggested.
Seeks to file additional document to substantiate the video. Let him do so within 1 week. Please, matter after 1 week. Yes.
72.
File everything so that it can be decided.
Yes.
You are seeking recalling of 5, 6 witnesses.
Lordship, I have
see
confined to only 3 witnesses. Lordship.
Why that 3? How will I know?
Your Lordships. I will.
You have to file.
Yes, Lordships.
Yes. Please do that.
Particular date will fix, Lordships.
Yes. Next.
72.
Urgent. Request admin. Yes.
73.
Yes, sir. 23.
73, my lord, may I please, my lord?
Yes.
My lord, nomenclature may be changed, my lord, because I have challenging the charge, my lord. So for CRL MC concern is, my lord, CRL REG, maybe it may be CRL REG, my lord.
Yes.
So I pray for change the nomenclature, my lord.
Yes, I understood it. Wait. Mr. Patil, let counsel for the petition submit that in the present petition, the order dated 19/10/2023 passed by the ad hoc additional sessions FSTC at Jaipur in city case number 75 of 23 has been assigned, whereby the charges have been framed. He seeks to he seeks a direction. He seeks to change the nomenclature of the petition. The oral petition, oral prayer of Mr. Padi is allowed. Raise is directed to appropriately assign the number by changing the nomenclature. Thereafter, release the matter before the assigned bench, subject to permission of the honorable chief justice. Next.
74.
Beloved, the petitioner is paying the maintenance amount to her wife since last 24 years.
Service.
Notice
not sufficient. The petitioner could take the fresh step.
Sir, I have filed a IA. Sir, on the next day, the 6/9, then there the
First, you said notice was issued long back.
notice issued, Your Honor. Notice issued and
Not sufficient.
Sir, Your Honor, the petitioner itself saying that I am receiving the notice, but I will not go to the High Court.
Where has he told you?
No, at the hearing of the court in the court.
File that affidavit. I'll have to see whether the service is affected because these are maintenance cases. Ex parte order can't be passed.
Sir, NBW will be issued on the next day, but tomorrow.
You come move application and cancel NBW. Try to understand these are maintenance cases. I can't pass an ex parte order. Once notice has been issued, notice has to be served on the wife.
Sir, please any stay order for the only for the for not issuing NBW.
Next slide.
75.
May I please? Your Lordship, part is my letter length. Your Lordship, it is the page 18 of my brief. The informant, who is the complainant in the intent case, initiated a proceeding. Last paragraph. In this case, there is no item of evidence against both the FR named accused person so and so, so and so, who are interested witness in
Where are
this,
you reading, sir?
my lord, page 18 of my brief.
Yes.
And
Which para?
last para.
No, sir. In this case.
There
There
in
is
this
no
case,
item of evidence against both.
evidence is there. Both FR named accused person so and so, and so and so, who are interested witness in this case, so and so, have gone conjointly lodged this FIR through the complaint Rasmita Pradhan, for which they are liable to be prosecuted under section 211 of IPC. This is the opinion of the investigating agency to initiate the proceeding against the complainant and other witnesses, because prima facie case is not there. And after that, my lord, a final report has been submitted. That has been accepted. Same sorts of evidence, again cognizance has been taken.
To me.
That is, my lord, on last occasion, your lordship directed me to
you
that the
are-
complaint
My lord,
petition
so-
along with the initial statement that I have got. Same exact evidence. That is the complaint I have folded.
You place it on record
My
and give a copy to him.
Last occasion, lordship directed it, it was also noting, my lord.
Huh?
Complaint
Oh,
petition
I-
207, nothing has been given.
You don't give the papers like this.
Sorry,
I
my
told
lord.
you last order is you
By
have to-
chatter, file copy.
That's right, but this order is you have to file that.
I will file.
Mr. Das, when counsel for the petitioner seeks 1 week time to place on record additional document is substantiated in case. Let him do so. Lease the matter within a week. Lease the matter up to 1 week. Yes.
Can I pray? IA is there.
Next.
Complaint petition, it is also complaint petition has not been.
Why don't you understand? Are you not wasting time like this? 3 hearing has taken place only because you are not filing document.
My lord.
And you are asking for a stay.
Sorted. My lord, I have already got. Sorted.
On that ground, I should have dismissed it.
So, by chatter, file.
My lord, this document also insufficient document. That protest petition he has not filed.
The same thing will happen. Anyway, so
Complaint petition along with
76.
May it please, your lordship. My lord, I have filed this substitution petition, death of this my lord, accused my lord, in this case, my lord, appellant. The appellant died in 25.
No, I have allowed the application.
No, my lord, it's
No,
pending, my lords.
Pending.
Flag K is pending.
Flag T.
K, my lords.
K. Allow
My
the
lord,
application.
my estate is there. I'm just what happened, my lord? Initially, some other counsel is appearing this case. In the meantime, this petitioner's present applicant's husband is died. He was the accused. Actually, this is the record of the vigilance. Because he's died, it's a criminal matter. We want to the family members, this wife and others will be included.
Yes.
This is the only thing my lord may allow.
394
provision.
Allowing it.
Yes. Yes.
The sole appellant in the present case has expired. Therefore, the present petitioners have moved an application under 394 CRPC seeking leave of the court to continue with the appeal. For the reasons stated in the application is allowed. Petitioner is directed to file amended memo of parties. Release the matter for final disposal.
There is another case at flag
my
M
lord,
for condonation of delay, my lords.
My lord,
Delay-
yes. There is a delay, the Laksmi that is
Yes,
condoned.
delay in filing the application under
Formal objection may kindly.
394 is also allowed for the reasons stated in the application. Mr. Rizvi appear for the vigilance and oppose the application vehemently. Vehemently.
Great.
Good luck. Great.
Now, this is over. This including the weekly. Yes.
77.
Yes, 77. Sorry? 330? Wait. No, Sanjay will decide what I don't go to the but he's trying to be very smart.
Lords, can it come next week? I'll have to file a reply.
The request of Mr.
We commencing 23rd.
23rd.
Yes.
Yes.
78.
And you have to put over. You call him to my chamber and you also. Henceforth, he will not.
Well, that's 78. It's ready for hearing, can be taken up in the weekly list.
Weekly.
79.
See, my lord, I am DCR Puri, my lord. In this appeal, my lord, no paperwork it has been done, my lord. I pray, may rest may kindly be ordered to prepare paperwork, my lord. So
No, in fact, Mr. Panigrai,
My
in
lord.
fact, we have done away with that practice. You can take the document soft copy by in a pen drive and prepare the paperwork and get it ready. Okay, I'm including it in the weekly list. It will be heard. Okay, weekly.
Another thing, my lord, my name has not been reflected in the cost list, my lord.
Mr. T. Panigrahi, name may be reflected in the cost list. Yes.
This is an appeal against the order of rejection by the competent authority, where I had filed an application seeking permission to operate my demat account. Let's understand first what is demat account. Demat account.
I know demat account. Tell. I know that.
Yes.
Go ahead.
Yes. So what I am saying, my lord, if anything, if there is sale and purchase takes place in that account, it is linked to a saving account. I cannot withdraw the money. My shares have become rotten over the years, my lord. They are now waste paper. So if I...
Who is appearing?
Yes, sir.
Yes, sir.
So if I am able to sell them, my lord, the money will go to the account which is under the custody of the vigilance.
They'll undertake not to withdraw. You can't restrict a demat account.
Yes, my lord.
You see, because this is linked to the market, they have to sell it, they have to take a call.
And the money will
And you have to secure the money.
Yes, yes, my lordship, I agree with his suggestion that let it be recovered and it may be deposited in the
yes, sir.
honorable authority.
Will not withdraw the money.
Not authorized officer, my lord. The demat account is linked to a saving account, which is under seizure of the vigilance authority.
You give me savings account.
Yes, sir. That is under seizure.
Account which is linked to that.
Sir.
You can continue the seizure.
And I promise I will not touch that account. I promise.
Account will not touch and the demat account will carry on.
Yes, sir.
The money flows to the
money and
ultimately current account or savings account.
Ultimately, if it is confiscated, state will be benefited.
Yes.
And if it comes to me, I'll be benefited.
Right. Petitioner is agreed by the order dated. Which order? Revisional this
no, the
authorized officer.
11/7/2023.
Authorized officer.
Sir.
Which account is that?
Demat account.
Demat account number. Petitioner is agreed by both the accounts are
demat. Both under seizure.
Which are those accounts?
Demat, first page, my lord, demat account number UTO 1069.
And which is the connected
saving account. Yes.
Where is that?
Saving account or nine.
Give me the number, otherwise there will be confusion.
The seized saving account.
Yes.
That number.
Are you sure that this demat account is linked with the seized one?
Yes, sir. Yes. Your lordship can write that. Your lordship can dictate that.
No,
seized.
Seized. Agreed by the order dated. I'll pass a general order by which here. Agreed by the order dated 11/7/2023, whereby the petitioner's application under section under which you moved application whereby the authorized officer you moved an application for 457 application. Run down or what?
Oh, this is a 13.
My lord, may I suggest one thing? Let them give the number of that seized saving account number to this.
No, I'll say that they will be allowed to operate the demat account, but the sale proceeds to be deposited shall not be withdrawn.
It will go to
simple
the account which is under seizure by the vigilance.
Because see, from demat account they can't withdraw. No. It has to go to some account. They can't,
and that account is under seizure.
Simple.
It's in their possession.
Simple. But the facts has to be known. That's the problem.
ଏବେ sir shares rates ବହୁତ ଟିକେ ଭଲ ଅଛି ତେଣୁ
Right. It is whereby the application moved by the petitioner for desealing the demat account, demat account number UTO 1069874 maintained in which bank?
Axis Bank.
In Axis Bank, which branch?
Bhubaneswar.
Axis Bank, Bhubaneswar. Do you have the account number one? You should have. You don't know which account, which bank and all.
With due respect, my lord, for the first time I'm appearing in this case. That's why.
I'll urge you to get the numbers.
Your lordship may pass that order.
I can't. Suppose I write it at Samudra Bank, Samudra account will be.
Yes, that is the
Well, even in the order itself, it is written Axis Bank Bhubaneswar, my lord. In the order
you get
itself.
the proper.
ଗୋଟେ ଡେଟ୍ ଆସୁ ଆପଣ ଦେଇଦେବେ ଆକାଉଣ୍ଟ ନମ୍ବରଟା
So casually I can't pass the order. You don't know the account number. You don't know the which bank.
No, I express my inability. My lord.
Your lordship,
Kind enough.
Get the number account and which branch. Otherwise, it is a very innocuous order.
Your lordship will fix a next week any date. 30.
Okay.
Get
the number.
ନାଇଁ ନାଇଁ 13ରେ ମୁଁ ଟିକେ ନଥିବି ମାନେ ଟୁ କମେଣ୍ଟସ୍ ଇନ୍
9th, let it be 9th.
Yes.
I'll dispose 9th.
Yes, sir.
Huh?
9th holiday.
This 9th. Acha. 9.
10
Let it be on 10.
Let it be on 10.
Let it be 10.
Sir.
10. 2 minutes matter.
ମତେ ଟିକେ ଆଗରୁ ଖାଲି ସେଇଟା ଦେଇଦେଲେ ମୁଁ ବି ଇନଷ୍ଟ୍ରକ୍ସନ ନେଇ
ଆପଣ ଆଗରୁ ଟିକେ ଦେଇଦେବେ so that unnecessary time.
ମୁଁ 9th କୁ ହି ଦେଇଦେବି ତାଙ୍କୁ।
ଏବେ ପଚାରିକି ଫୋନ ରେ ଦେଇ ଦଉନାହାନ୍ତି ନମ୍ବର ଗୁଡାକ।
ସେଟା ଗୋଟେ ଡକେଇବି I will call him.
81. Yes, sir.
The conviction is 3 years, 20,000. Conviction is 3 years, 20,000.
Fresh appeal.
Again?
Fresh appeal.
Yeah.
Appeal admitted.
Delay is there, so first delay to be condoned.
That way, not opposing, na?
No. Delay is to be condoned.
Delay in filing the appeal is condoned. Appeal admitted. Bail granted. Realization of the fine amount is stayed. Call for the record. LCR. Release the matter for disposal.
Bail.
Sanjay Singh,
Bill.
number name.
Okay. Yeah.
2 appeals are there.
Two appeals. Both the appeals.
Both the appeals.
Both the appeals. 82.
But 82, I'm appearing for the petitioner.
Yes.
There are 3 connected cases, my lord. But all that I'm praying that if the matter can be taken up next week.
Serious objects are
But it's 2017, there's a stay order and
My lord, I have also
there is
serious
a
objects,
legitimate stay order.
Interim order is there.
My lord, my submission
I'm ready
is
to finish it up. I'm only
2
saying-
check bounce case in this involving the CRLMC. One is stayed at the stage of argument, and the other is stayed at the stage of completion of the defense evidence. I will produce the copy, my lord.
You are the accused. They are the informant.
Yes,
In
check bounce.
one case,
I am
they
the
are the
complainant.
accused.
I am
And
the complainant.
in two cases, I am the accused. But there's a nature of case and cross case, and I'm covered by the Honorable Supreme Court judgment, which says that when there is a nature of case and cross cases arising out of the same cause of action, both these cases, all these cases, they need to be clubbed together and heard together so that there is no conflicting judgments. And then there is a stay order since 2017.
No,
and
all are independent 138 cases.
Yes,
there are
Treated separately.
No, there are two 138 cases which have been filed against me, and there is one criminal case which has been filed by me against the complainant in the check bounce case, my lord. So therefore, my lord, all these 3 cases, they need to be clubbed together and heard together. That is the issue involved over here. And all that I'm praying, I'm ready with the matter. The matter can be taken up If not Monday,
I have no issue, but there is opposition.
But my son, your lordship for a moment, my lord, let me complete. I will state
but it's
only few lines. Thereafter, I have nothing to say if it is adjourned.
but I have
Your lordship
accommodated.
may kindly see the order sheet, my lord.
But he has a personal problem.
So far, my clients are concerned, they are the police officer, nowhere related to this particular case, but they have been tracked. Two checks have been issued. Now, whether they have been after the expound, whether it will go to the credit of either side.
Why? Is there any chance of settlement? No.
No.
What is the check amount?
Check amount would
1
be zero.
crore 96 lakhs.
96 lakhs.
Two check. 1 crore 96 lakhs.
But it forcibly,
What is the check they have given to you?
Ma, that is admitted. There is no dispute. That is admitted.
forcibly those checks were handed over to me, to them, with the intervention of the police, my lord.
Police is
In the police station.
Police station.
In the police station. I was dragged to the police station and I was asked to hand over those checks.
And you filed a criminal case
Yes, my
against
lord.
the
Yes, my lord. And the magistrate,
complainant as well as the police officer.
magistrate did not take any cognizance against the police officials for want of sanction, for which reason I filed a separate criminal revision. So all this matter can be heard together, my lord. And so many times I've accommodated them also.
No. It has been inquired into by the authorities, found to be false. That's why no sanction. But till then, my lord, because of the fact that he wants to get rid of the particular checks, which is
My lord, I will place the complaint
That is
case.
his defense basically.
I will place the complaint case as well as this criminal miscase.
Anyway, I'm just accommodating.
Only one
personal
date, my lord.
cause, one.
Suddenly this matter has come up, my lord. I need to-
Generally, it doesn't ask time.
Yes, my lord.
He's always prepared in time.
Next week, my lord.
Next week, देखिए दे दो. He will start next week. He'll adjust a date and give you.
My lord, order has been passed that it will continue, but judgment will not be delivered by this court also. And thereafter, in the second case, he is not participating for giving defense evidence.
What I'll do is I'll decide his case first.
Yes, my lord.
No, my lord.
That is his defense.
First, my case will be decided because I have filed the criminal revision for quashing the cognizance. If that will go,
Cognizance taken against you.
Yes, my
in
lord.
his complaint.
Yes.
That's what I'm saying.
Although my case, no.
If that is fast, everything.
Yes, then clubbing up together or not, that will arise. And so far my friend is concerned, no cognizance against him.
Because sanction, lack of sanction. Therefore, he filed a separate complaint.
Yes. So my case will be taken up.
That matter first I give.
Again.
Your lordship is calling it out.
He's giving a date.
Next week, any date.
Interim orders in the
interim order will continue, but let him look at the board and adjust accordingly.
Management indicate no further time will be taken.
It is made clear that no further adjournment shall be granted in for any reason whatsoever. Yes.
83.
Okay, please wait. Don't pressurize. He'll give a date. Then same thing will happen. So let him apply his mind. He has to adjust. Out of pressure, he gives the date. Thereafter, things are the same. You please just be in touch. Your junior, tell me.
Next week, any date?
Yes, sir. Yes.
83.
My lord, this matter may be taken up next week.
Next week. Urgent. Yes.
I beg to appear for the petitioner. This is a quashing petition. May recall this is a case where there was a loan taken for purposes of construction of a highway. The contract came to be terminated midway, and there was some difficulty in repayment of loan. Subsequently, there has been a one-time settlement. There are some dates, my lords, if I could point out. 2000.
The complainant. It is
the Central Bank of India, my lords, is the complainant.
CBI is.
And the prosecuting agency is CBI.
CBI, okay.
Plus 2011, a two-lane work between Damo and Hirapur in Madhya Pradesh was given to me on contract on built, operate and transfer basis. My lords, we applied for a loan.
You are challenging cognizance order or what?
My lords, the cognizance as well as the charge sheet, my lords. My lords, we applied for a loan from Central Bank. Central Bank sanctioned the loan. The total project cost was about 124 crores. My lords, 87 crores was the finance we were taking and 37 crores is our own equity that we were putting in. My lords, 62.55 crores came to be disbursed over a period of about 1.5 years during the construction. My lords, we were not able to meet the milestones. This is what the case of Madhya Pradesh Road Development Corporation Limited, the employer of the contract is. They terminated the contract. My lords, we initiated arbitration because they removed us and they were going to retender it again. So while that arbitration is still going on, now whatever work we had done and whatever we had done, we didn't get any proceeds out of it because we had a right to collect toll for 20 years.
Yes.
Now, throughout this period, my lords, we continued to be in touch with the bank, writing to them, negotiating and coming up with a way to pay. If my lords can have a letter at page, central bank's letter at page 123, just to show my bona fides, my lords.
Yes.
At page 123.
Now, what is your proposition, you tell me?
My lords, I am relying
If
upon.
there are a lot of complicated facts, overlapping facts, and those things has to be, sorted out there in the trial only. At this stage, I can't go into nitty-gritty of everything.
My
Your
lords,
defense,
I'll just crystallize my proposition, as my lord said. My lords, I'm relying upon Nikhil Merchant versus CBI and BB Agarwal versus CBI. I'll straight away take my lords to that case. Those cases were again where loan was taken from a public sector bank, and CBI was the prosecuting agency. But there was a one-time settlement done. Thereafter, Supreme Court said that there's no purpose in pursuing with the trial. It will be abuse and it will be a prolonged process.
your
In those
cases,
cases,
once OTS has been done,
my lords,
you could not comply the OTS condition.
I have complied, my lords. OTS is done.
Then
OTS is done. My case is that there's no point in pursuing the criminal prosecution, my lords.
OTS is accepted as a bank.
Yes, my lords, and I paid the money also. They have, in fact, pursuant to that, filed an application before DRT.
While availing bail, what have you done?
While availing, my lords?
While availing the loan, what have you done?
My lords, I executed work at that place. I worked there for about 1.5 years. There were some disputes with Madhya Pradesh Road Development Corporation Limited. They said that you have not met with the milestones. We say that we have met with the milestones. They have terminated the contract. I am pursuing my claims in arbitration. So I have not got any money out of the money that I had invested. But out of my own pocket, I have still done a one-time settlement and repaid whatever I could to the bank. And it has been accepted before DRT also. If I could, my lords, point out
the offenses. What are the offenses?
My lords, 120B, 420, 13(1)D, 13(2). Because two officers of the bank are also involved.
Who all are the officers?
Yes, my lords. I may just point out, my lords, there is no forgery here. There is no allegation that I cooked up or fabricated a document to get a loan. To that extent, there is no deception that I lied or created a document. It's an admitted position that there was a work contract given to me, a concession agreement by Madhya Pradesh government's PSU. There was a tripartite agreement between the bank, Madhya Pradesh Road Development Corporation Limited, and myself. So to that extent, my lords, I have not deceived in getting a loan. All these facts are there. These are a matter of fact in the charge sheet itself. Now, my lords, I'll just point out one application filed by the bank itself. First, I'll show the OTS, my lords, at page 157.
Yes. Yes. Is it a part of the charge sheet?
My lords, this is a part of the paper book. It's a OTS document is a part of the charge sheet otherwise also. And at page 157 of the
I think
paper.
you are relying upon many documents which may not be the part of the charge sheet.
My lords, I am relying upon this OTS document. There is an order of DRT, which is an order of court, which I can always point out. And other than that, my lords, I will not show any document. I will only point out the judgments thereafter.
Yes.
My lords, may kindly see at page 157.
Yes. I'm there.
Yes, my lords. And my lords, the OTS has been mentioned in the charge sheet itself. So it's not a disputed fact.
The OTS might have been, mentioned in the charge sheet. Whether these documents which you are relying upon.
Well, I'll just show the
cognizance stage.
Just the OTS document.
Part of the charge sheet or not, that's the question.
Well, it's a part of the charge sheet, the OTS document. I'll only rely upon
Let me
this.
verify. Yes, Mr. Nayak. Whether
Yes,
the document relied upon by the petitioners.
There is no settlement, Your Lordship. There is
part
no
of the
settlement.
charge sheet.
Your Lordship, there is no settlement. Bank has only received a part due, and bank has given an affidavit, filed an affidavit before this honorable court.
Hey, what is the offense? If a loan is taken, OTS has been worked out, and he has paid part of the amount, he has not paid part of the amount.
No, Your
What
Lordship.
is the
No,
criminality?
Lordship.
That's what,
The basis
what
of,
I'm
Your
saying.
Lordship, the basis of taking of the loan
Yes,
is a
that's
crime.
what I wanted to ask.
Criminal. Lordship, let him argue. I'll bring all the aspects before
Now
this
you
honorable.
tell me overall, otherwise
In a
Lordship,
cognizant stage, why should I keep on hearing for?
Lordship may kindly come to the charge sheet
Yes.
and charge part
Tell
straight
me,
away.
tell me overall what is the.
I want to read it, your lordships.
Yes.
Sunil Agarwal,
Huh?
he is the promoter director of ARSS.
Yes.
Let me read it, your lordships. From the charge sheet.
Yes.
He is one of the 4 brothers who are promoters of ARSS group. He is one of the directors. He was authorized person to execute documents on behalf of such and such. And in his capacity, signed all documents and accepted all the terms sanctioned such and such. 87 crore sanctioned by the Central Bank, Janpat branch. He is also a personal guarantor of the term loan sanctioned by the Central Bank of India. He submitted request letters to bank for disbursement of loan term amount running such and such, showing Damodar such and such. Now, your lordships, showing what he submitted request letter to bank for disbursement of term loan, including running account bill from 2011 prior to 27/12/2011, showing work done at Damo Hirapur project, whereas the work was started only on 27/12/2011. He submitted a false list. Lordship may note it down.
That you emphasize. False list, yes.
He submitted a false list bearing the title Assets at Damo Hirapur MP with his letter dated 24/4/2013, stating that vehicles, plant and equipment worth 32.56 crores were available at the project site, even though the same has been financed by another financial institutions, were hypothecated to them even before the release of the first tranche. After disbursal of the loan amount, he violated the terms of the sanction and did not use the money for which it was mentioned. He also did not repay the outstanding amount of the bank. The term loan rupees 56 crores such and such disbursed during period such and such was diverted to regularize irregular cash credit loan of RSS A6 State Bank of India. He diverted the money, your lordships. Now elaborate documentation of the merits of the case and detailed examination.
Exactly, have 2 allegations. One is he has given a wrong declaration, false declaration. Second is he diverted the money taken for a particular project.
Thirdly, your lordship, there is no settlement. Part payment of, suppose if a lordships, I take 100 crores from bank. I misappropriated 80 crores. I come with a one-time settlement, pay 20 crores and due 80 crores and say that there is settlement, I will be absolved of the criminal liability.
That's right, but what is the, unless you make out a case, criminal case.
And the judgments, and your lordship, the judgments which is showing has been overruled by the Honorable Supreme Court. Lordship, the judgment he has cited, I'll cite a recent judgment of the Honorable Supreme Court. Supreme Court is saying that, Supreme Court, your lordship, is saying that cases under Prevention of Corruption Act cannot be quashed even if there is a compromise.
Yes.
No. My lords,
Yes,
in
yes,
fact,
yes.
Nikhil
Yes,
Merchant
yes.
was referred to a 3-judge bench that has upheld the correctness of Nikhil Merchant.
Lordship, may kindly come to your
My lords,
lordship.
the entire one-time settlement amount has been paid. The bank itself filed an application before DRT saying that in full and final settlement under the OTS, monies have
Lordship,
been paid.
Nikhil
They are
Merchant-
withdrawing the application.
No, Lordship,
That order is
Nikhil-
also on record.
No, your
Admitted
lordship,
by the bank.
Have they withdrawn? So
They have withdrawn from
They are
DRT.
withdrawing.
DRT produce, they have withdrawn it, my lords.
So, lordship, may kindly come
Filing
to
a
the letter
withdrawal
of the bank.
application, I put the order also, I put the application also, and it's an
Lordship, may kindly
admitted
come to the
by
letter of the
bank.
bank for a moment. Your lordship, may kindly come to my counter affidavit. I have annexed a letter of the bank. What the bank has to say.
Yes.
The bank, your lordship, is saying that. Lordship, may kindly see. My
bank
annexure.
bank can't enter into a OTS, taken the money, file an application before the DRT saying that I have settled the dispute.
No,
and
no, no.
withdraw it,
No, no,
and
not
thereafter
settle the
you
dispute.
pursuing the criminal case also.
Bank is saying that criminal action will continue.
That's a separate issue, my lord. The
Lordship, may kindly
one-time
read.
settlement
Lordship, may
has
see
been
what the
done.
bank is saying. No, no,
Entire
one-
money, entire every paise under the one-time settlement has been paid.
Lordship's
To
one-time
that extent,
settlement
my
only-
lords, the CBI must be
Please,
fair
please,
in pointing that
You
out.
should
Let
have
me
in
argue.
OTS, in the OTS, when you paid, you should have said that I am paying subject to remove, subject to withdrawal of all cases.
My lords, I'll point out.
Criminal action should continue.
My
The
lords,
bank is saying.
Line is there that.
No, my lords, I'll point
you
out.
agreed
My
that
lords,
let the
Lordship, may
criminal
read
case
that
go
line.
on.
My lords, I'll point out, my lords.
What to do now?
My lords, I'll point out.
Bank has filed
Any-
a counter affidavit in this case also, where bank has annexed a letter in which bank is saying that the criminal action will continue.
I've seen that. I've seen that.
My lords, that's
And all-
exactly the letter I was wanting to show at page 157, which my lords were asking is a part of the charge
Have
sheet.
you not signed that?
My lords, I've signed it. I've signed it.
You have agreed that let the criminal case go on.
My lords,
Yes,
I've not
yes.
agreed.
Now you are
This is-
back up the same.
My lords, I've not agreed. It's not in the form of an agreement. It's a OTS letter where one condition, if I could just take it at page 157, my lords may kindly have it. My lords have it.
Yes.
My lords may kindly see the first line on the subject matter.
Read the relevant part. Don't read the full letter.
the
Point
the
five.
relevant the OTS portion is first para. I'll straight away take you to clause 5, which my learned friend is pointing out. Serial number 5, criminal action will continue. Now, my lords, here I just wanted to point out this criminal.
Column 5 says.
I'm saying, my lords.
Criminal action will continue.
Yes, my lord.
And column 6 says all litigation filed by you against the bank should be withdrawn. You have agreed to that.
My lords,
Apart from that, your lordship, the bank has.
If I could, Sarthak, if I could, you made a point. I'll just
Yes,
answer
yes,
this.
yes. Go.
My lords, I have withdrawn, not an issue. They have also withdrawn before DRT, not an issue. Now coming to clause 5, my lords, I am saying, my lords, suppose if the public sector bank official would have said that the criminal action will not continue, would my lords have caused on those that basis? My lords, because he doesn't have the power.
I'm not having these things are
My lords,
have no
because-
relevancy.
Exact.
Then you have to make out a case on merits.
My
Don't
lords,
rely on these documents.
no, what I'm saying, my
OTS,
lords,
OTS,
my lords,
leave it.
my lords, what I'm saying
Whether
is,
the case is made out or not, tell me.
my lords,
You
this is,
relied upon these documents, so therefore I'm
my
saying.
lords, this is not within the jurisdiction of the bank official to say. Now the two cases I'm
You
relying
can't be-
upon.
See, you
My lords,
accepted. See, that might be the reason at the very. What was the loan amount?
my lords, 62.
What was the OTS amount?
62.55 crores was disbursed.
Yes.
40 crores is OTS, 10.21 crores paid
So
in
bank
interest.
has agreed
Yes, my lords.
on
I
that
paid 52
particular amount
crores.
only because of this that you will face the criminal case.
My lords,
That
OTS.
bank would
one
not
of
have
the reasons
prosecuted
for
its own
making
employees,
the
your lords.
OTS at a very lower level.
My lords,
And moreover, your
OTS,
lordship,
as my
bank.
lords,
Go take 1 minute. Your lordship, the bank has prosecuted its own employees. Bank has given a sanction. Bank cannot say that you prosecute my own employees, but I'm questioning proceedings
Sarthak,
against
give the
them.
facts correctly. My
I
lords,
understand
when
it.
I'll just point out, when the bank filed a complaint,
But you have to make out. You have to now make out a case whether on the basis of the allegation and the charge sheet
My
and all,
lords,
no case is
this
made
is-
out
Yes.
against you.
my lords, what I'll do is, my lords,
Don't rely upon this OTS business and all.
my lords, the two case laws I'm relying upon of the Supreme Court are cases of OTS where again there is no consent from the bank or any condition from the bank whether the criminal case should continue or not. The court on its own has said that it will be an abuse of process and it will result into a prolonged trial with no use because the money has been paid under OTS accepted by the bank. So, my lords, there also, it's not that in those OTS conditions, there was a line saying that the criminal action will come to an end. It is not that. I'm only on the proposition that has been upheld by Supreme Court. Just two judgments, my lords. If no case is made out, my lords may kindly dismiss it. My lords, if I may pass on this compilation, it's been given to Mr. Naik and Mr.
Judgment now a big compilation.
My lords may only see the first two.
PB Agarwal and Nikhil Merchant.
Yes.
Yes.
My lords may kindly have the first judgment. First judgment, my lords. This is Nikhil Merchant versus CBI,
Yes.
2008, volume 9, 7 SCC. I'll just show the offenses in para 2 at running page 3. My lords, this is a verse of case here. There is forgery also, right at the inception. Para 2, my lords may note 420, 467, 468, 470.
I've seen it. Next.
Very well, my lord.
Yes.
Now, my lords may kindly see the CBI's argument at page 24.
See, ratio decently you show me.
My lords?
Show the ratio decently. Don't read out the entire fact.
Yeah, okay, ma'am.
What is the ratio?
My lords may kindly see 28.
28. Okay.
28, para 28 at page 8.
Nimuts is relied upon.
My lords, para 28.
28 I'm reading.
Yes, my lord. As this was a case, there was a lot of misrepresentation, false documents used. Now, para 28 and 30. Two paras I will read.
Just read page para 30.
In the instant case, the disputes between the company and the bank have been set at rest on the basis of the compromise arrived at by them, whereunder the dues of the
Underline
bank
these lines.
My lord,
On the basis of the compromised arrived
at by them, whereunder the dues of the bank have been cleared, and the bank does not appear to have any further claim against the company. I will show in the DRT application, bank says we have no further claim from this company. I will show that line, my lords. In my case also.
rightly they are saying they have no claim.
My lords, my lords.
They have no claim.
My lords.
But it's not a case of complete compromise insofar as criminal case is concerned.
My lords,
The
here,
ratio will not help you.
my lords, here also, there is no line in the compromise or the OTS which says that the criminal case will go, because the bank official cannot say it, my lords, even in this bank or any other bank, even in the next case. But let me just continue, my lords,
But
with
this
this
is
paragraph.
a unique OTS I have seen.
My lords, I'll just continue with this. My lords may see, even in these cases, there is no such condition. What, however, remains in the fact is the fact that certain documents were alleged to have been created by the appellant herein in order to avail of credit facilities beyond the limit to which the company was entitled. The dispute involved herein has overtones of a civil dispute with certain criminal facets. The question which is required to be answered in the case is whether the power which independently lies with the court to quash the criminal proceedings pursuant to the compromise arrived at should at all be exercised. On an overall view of the facts as indicated herein above, and keeping in mind the decision of this court in B.S. Joshi and the compromise arrived at between company and the bank, as also clause 11 of the consent terms filed in the suit filed.
Why don't you understand? See, this matter where there was a compromise and they approached 482 court and court
My lords,
rejected.
here,
Thereafter,
both parties had not. My lords, it wasn't a joint petition.
There is no compromise.
My lords, it was not a joint petition in this case also.
But here there is no compromise in your case.
My lords, there is an
With due
OTS.
respect.
There is an OTS.
OTS is something different.
My lords may see the next judgment. My lords, again, it's a case of OTS. There are, please
Both
see.
the
My lords.
judgments are.
Yes. Which one?
My lords may
There
kindly
was
see.
a clear-cut compromise.
My
Here
lords,
there is no compromise.
my lords, those were
Insofar as
also,
criminal cases
my lords,
concerned.
those cases were also one-time settlement. I'll show from the
So therefore,
facts.
merit only you can succeed.
My lords may kindly see para 6 at page 11 of BB Agarwal of one-time settlement. Let me just show my.
BB Agarwal.
Yes, my lords.
Yes.
My lords may kindly see at page 11. Para 4, just want to point out there is forgery. It's a worse of case in terms of offense. My lords, para 6 at placetum G. It is also not in dispute that during the pendency of these civil suits and pursuant to orders passed therein directing the parties to undertake reconciliation of the accounts, PNB and the two companies through their directors reconciled their accounts and compromised the matter by entering into a one-time settlement on 6 June 2006. Para 7. The DRT by its order dated 11/5/2006 accepted the settlement and accordingly disposed of OA in terms of settlement exactly as has been done in my case, my lord.
Read para 12.
Para 12. The High Court was of the view that on resettlement of
Read
accounts.
carefully.
My lord.
Read carefully.
Yes, ma'am. The High Court was of the view that on resettlement of accounts, the parties obtained the consent decree from DRT and paid the entire sum thereof. There is no live issue which now survives. The High Court then examined the question as to whether the issue of criminality is involved so as to allow the trial court to continue on its merits. After examining this issue with reference to charges and documents, the High Court held that no criminality issue is found involved, notwithstanding.
Criminality is found, notwithstanding the
My lord,
settlement.
it was a case of false
So
documents.
then on merit you satisfy me there is no criminality.
My lords
Don't
may,
rely upon the
my lords may kindly see at para 15 also. This was a case of forged documents, which is not the case here.
What is the ratio? See the ratio. Ratio is if there is a compromise, it can be done. No problem.
My lords.
Here there is no compromise.
My lord.
Because the bank says that irrespective of the OTS, civil liability goes,
My lords.
but criminal liability will go on.
My lords.
So therefore there is no consent and compromise.
My lords.
So in that context, you have now challenged that on the basis that I have paid. So therefore the criminality goes. Criminality doesn't go. All the judgments.
So, my lords,
in
what
those
I've done
cases,
is.
the bank have given the consent.
So, my lords,
to
what I've
withdraw
done
the
is
criminal
in
case.
BB Agarwal case, my lords rightly pointed out that the High Court said that despite the OTS, there is no criminality. So, what I've done is I've also annexed the High Court order at serial number 3 in the same compilation.
Yes.
Please see. It's a case of forgery.
Again on merit.
My lords, I'm saying there also. They
BB Agarwal is on merit.
My lords, again, I'm saying they did not go into the facts or the merits in the sense that there is a forged document, that there is criminality. The basis was this only, that there is an OTS and there will be no purpose solved. I'll read para 15 of the Supreme Court judgment, then I'll show the Delhi High Court judgment. My lords of Justice Muralidhar.
In those OTS,
My lord.
whether this condition was engrafted into the OTS.
My lords, it's not mentioned. It from the judgments, it's not.
Difficult.
But my
That's
lords.
what I'm saying. This is a unique OTS. Without minus this 5, clause 5, if there would have been OTS, if they insisted for it, I would have quashed it.
My lords.
Now, since this
My
clause
lords,
is
if-
incorporated in the OTS
My lords,
itself,
I-
so except the on merits, I perhaps I cannot quash the proceeding at all.
My lords, if I may put it this way, the purport of para 5 or the relevance of it here would be that they have not, the bank has not consented to quashing of the criminal proceedings.
So there is no settlement or there is no.
But there is a
compromise
settlement.
in so far-
OTS.
Settlement for.
This is only a part payment, your lordships.
But even in, I'm saying, even in Nikhil Merchant and BB Agarwal, where CBI is the prosecuting agency, do you think, my lords, that the bank was competent to otherwise compromise that the case should be quashed? I don't think so, my lords. Even there, the bank official couldn't have said that.
Can you arrange the OTS of Agarwal and?
My lords, the quantum of OTS and all that is mentioned in the facts of the judgment itself.
Can you get the OTS document?
My lords, my lords may give me 1 week's time. I'll find out.
Better that if you can
Your
show me.
lordships.
I'll find out, my lords.
With this condition, if the OTS was there, and even then the court has quashed it, I will straight away rely upon these two judgments and quash it. Otherwise, I will relegate you to the trial court to argue all these points at the time of hearing.
If I give you one.
My lords, if my lords could be even more indulgent and say, if in the OTS, suppose there is nothing and there is an absolute silence on the criminal case, neither consenting to quashing nor not consenting to
Then
quashing.
the situation would have been different. Then straight away you are covered by marchand. Straight away you are covered by marchand.
Then let me inspect, my lords. I'll see.
But for that clause 5, these two judgments are not helping you.
My lords, I'll try to take out the OTS from
Your lordships.
1 week
Your
time.
lordships, just 1 second, your lordships.
Yes.
Lordship, the date of Nikhil Merchant's judgment, if your lordships will see, Nikhil Merchant is of 2008. And this BB Agarwal's judgment, your lordships, is of 18/2/2019.
That apart, see, the problem is
Your lordship,
your lordship, while signing, they should have been more careful about it.
No, your lordship, 17 days after this judgment, 17 days after this judgment, on 5/3/2019, there was a judgment by the Honorable Supreme Court, State of Madhya Pradesh versus Lakshmi Narayan, which he is not pointing out. There, your lordships, the court
I'll
is saying
point out
that.
what Mr.
Just
Naik
1
is
minute.
not pointing
Please
out.
wait.
There's
Please
a
wait.
reference order
Please wait.
referring Nikhil Merchant's correctness to a
Please wait.
three-judge bench, which has been decided in
But
Gyan
lordship,
Singh
may kindly
versus
read back.
CBI,
Please
and
wait.
it's a part of the compilation.
Please wait.
Different pedestrian.
No, your
My
lordship,
lords,
may
the
kindly
only
come to-
question is whether Nikhil
Just 1
Merchant is
minute.
good law or not. That's the reference in
Your
Gyan Singh.
lordship,
my lords.
similarly, such
It's
power
at
is.
page 60 of the compilation.
Your lordships, the Honorable Supreme Court is saying that the powers under 482 is not to be exercised for the offences under the special statutes like Prevention of Corruption Act and offences committed by public servant while working in that capacity are not to be quashed, merely on the basis of compromise between victim and the offender. So the Supreme Court is saying that PC Act cannot be quashed, your lordships, even though there is a compromise.
No.
Accepting
my
without
lord.
admitting for the sake of arguments.
Now, my lords, at page 60, one paragraph at page 60, which says,
That will not.
my lords, this is three judges, which says,
The problem is the OTS. He has
Such,
my lords,
such power, your lordship,
at
in
page
any
60.
case, I am adjourning by 2 ways.
I just wanted to point
Such
out
power is not to
to
be
my
exercised.
learned friend is perhaps not aware of Gyan Singh. This is three judges.
I have
They
read
have
Gyan Singh.
upheld the correctness of Gyan Singh, and on the point of Prevention of Corruption Act, they say that ideally a case of Prevention of Corruption Act should not be caused on compromise, but if there is a civil dispute or a financial transaction, in that case on compromise it can be done. I just wanted to
There are
point
also,
out
there are also judgments that even if, your lordship, there are also
You show
judgments.
me the OTS.
My lords, I'll try
Marchand
to
and
get.
Agarwal.
I'll try to get.
Your lordship, there are also judgment if a civil case is pending, that doesn't take away the culpability or criminality of the
There are
offense.
judgment
It's a direct
either
court
I'm not advancing that proposition. My
I
proposition.
request your lordships to leave these things to trial court, your lordships. Instead of doing a mini trial, he's arguing on the merits of the case.
My lords,
You
giving me
want
1 week
you want to
opportunity.
show the OTS, let us see the two judgments which is citing will help or not. Let us see.
My lords, perhaps if there is a similar condition, then
Yeah, maybe. Then maybe you have a case, you may be
My
covered
lords, my
by
lords.
a marchand and as well as others. Yes. Next.
85.
My lords. Would my lords indicate a date? My lords.
After puja vacations, your lordships.
Great.
Lordship has given a date.
Yeah, he is giving a date, don't worry. He'll give a date.
After
Item
puja vacations, your
85,
lordships.
my lords, on behalf of my senior Mr. Kanungo, due to some personal difficulty, I pray next time.
86.
My lords, interim order to continue in item 85.
I'm sorry that I gave an indulgence, but 103 probably your lordship will not take it up today. Your lordship may fix a date and time when your lordship is free so that we can at least.
How do I know when I'm free? That's the whole.
No. I thought your lordship will finish these matters.
ଗୋଟେ ତିନିଟା ମ୍ୟାଟର ଅଛି ସାର୍ କହୁଛନ୍ତି ଗୋଟିଏ ମ୍ୟାଟର ଟେକଅପ୍ କରିବେ ଗୋଟେ ମ୍ୟାଟର ତିନିଟା ବ୍ୟାଚ୍ ଅଛି ଗୋଟିଏ ଟେକଅପ୍ କଲେ କଣ ଏବେ ନାହିଁ
So what do you suggest, Mr. Panda?
I have no suggestions. I am asking your lordship to give me a date.
No, you tell me which date you suggest. If one matter is stuck, then 10-15
Next
is
week
good.
I am available on Tuesdays and Friday.
Just take it up if you can.
Next week.
Leave next week. Next week, which situation would be, I think.
The
more or
other
less
week I am not available except 17th. 17th is the only date I am available in the third.
Sometime at 4 o'clock, I have to hear. That's the only solution.
4 o'clock I will not impose upon your lordship.
What to do then before?
It will take 20 minutes. Question only 20 minutes. So charge sheet I should have become a witness rather.
There is total 17, it will be used. If not, we have 3 quarters.
Adjust.
17.
70.
2 PM doctor.
Yes.
That's not that. I mention
Let it be 3.
May I suggest one thing, my lords? Once a few cases, my lord, clubbed together, my lords, that's one of the major reasons for the so much time is required, notice submission and all this thing. This is also a case, my lord, a taste case. Lordship may put that particular date, that one case, on the top of that bunch of cases, my lord.
I will take hardly 15
Yes,
minutes.
15,
If your
20.
lordship will
Means
see
about,
if your lordship will see
hour.
the charge sheet, I think half an hour is enough. At 10:30, if your lordship fixes it, at 11 o'clock, your lordship will free.
Say go to first case.
Dispose of every other matter on.
If you can split it, my lords, in one segregate.
Let it be 2 o'clock. What we will do is immediately after Passover, we will take up their matter. Thereafter, the bail matter we can cross after 4 o'clock. Also, bail matter can be taken up. We'll make them free by.
Again, I suggest, my lord, that
And written note and everything ready.
Not necessary. A written note is not.
But still, it's easier for me. Prepare a short. Whatever you are referring, please note those things from paperwork. Otherwise, while giving dictation, I'll keep on searching things.
the lordship permission may reiterate, my lords. This top case, the first case may be taken off on that, my lord. It will be disposed of, my lord. The other thing will follow, my lords.
No, first case,
Yes.
one case will be taken up at 2 o'clock.
Exactly, agreed.
On 17. Okay.
And it will be disposed. I assure this, your lords.
Dispose of, then other case also
Correct,
can
my
be
lords.
disposed of.
Club of means then the entire combustion procedure
How
starts.
many matters are there?
There are 4 cases, I haven't club, my lords.
First
The
case.
individual complexity will differ from case to cases.
Yes, next.
The interim order.
Only mentioning. The rest of the matter will be spilled over.
Interim order.
Interim order to continue.
Whereas item 85, may I pray interim order to continue?
Interim order is there.
Yes.
Any mentioning. And the rest of the matter will spill over to tomorrow.
Pardon, my lord.
Which one?
Matter was supposed to be referred to mediation. There's an order.
88.
88.
Yes.
No, 88.
Here, your lordship.
What happened?
99, not 88.
88, my lord. My humble submission, 88, there is an interim order is there, your lords.
No, this will be taken up tomorrow.
Yes, sir.
I have a prayer, my lord.
99 mediation center already
There is an order. There is previous order.
You are awaiting.
Yes.
Awaiting.
Reference of bill number 2, it will be referred to mediation center.
It has already been referred or
Yes, and hey.
There is an order on my appearance. Matter will be referred for mediation.
Acha, right now.
Now he
99. 99.
Item 99.
99.
89.
Are you related? What kind of
No. It's a civil dispute.
Civil dispute. Which is that?
There is an order.
Okay. Pursuant to the order dated 24/7/2024, Mr. Rajit Roy entered appearance for opposite party number 2. Opposite party number 2. As per the direction of this court, the matter is referred to or direction of this court dated 24/7/2024. The matter is referred to High Court Mediation Center. The coordinator of mediation center is directed to fix a date for exploring the possibility of settlement. intimate the date of, intimate the date to all the parties concerned. And after the mediation, file a report before this court. Awaiting mediation report, leave the matter after 3 weeks.
Item,
Along with this.
item 89, my lord.
Happy for him. Mediation.
Item 89, my lord. I have filed a IA, my lord.
And
The IA has not come with this CLMs, my lord. Your lordship may direct.
What?
IA for extension of my lord. I have already, your lordship directed.
Just check it up.
IA number 1106.
This will be taken up tomorrow.
Yes, my lord. IA number 1106.
To continue.
IA number 1106 in CLMC 4340 and IA number and IA number 1107 in 4341.
1 week after. Urgent.
My lord, can you be taken weeks after, my lord? 93, my lord.
93 urgent.
And my lord, this matter is continue.
Tomorrow I'll take it up. I'm not adjourning the matter. Those who want adjournment, tell me. Otherwise, it's spill over. Any? Which one? 91 what? Huh? Not taken up. Tomorrow I'll take it up. Okay, thank you.
Sir, I project.